of bail application. It will come serially.
Item 64, interim bail application may be taken up first because I have to
What
collect
ground?
Death case
that
wala tension.
death case,
Death case.
drowning.
Okay, I'll take it up.
Lordships, last Monday I had mentioned a miscellaneous application of washing. Lordships have been pleased to put it on Tuesday today. Lordships not listed. So washing matter, my lords, I had mentioned specifically.
Was it placed for today? If I've said it is today, means it's today.
Lords, I had submitted that application and the slip also last time. And Lords been kind enough to say it on Tuesday 3rd.
Just check it up and tell me. If any,
But then kindly take it up tomorrow, Lordships. I file additional documents.
I'll just check it up.
Please, Lordships.
I want to go into deep into it. If I have said Tuesday, means it should be Tuesday. It can't be,
And Lordships was kind enough to also understand that you, Lordship mentioned that he is coming from outside, so put it on Tuesday.
If possible, let's take up 3 o'clock.
Then
If
2
possible.
PM
No,
Lordships.
it's not so urgent. But I'm worried about one thing, that if I'm setting the board according to my pressure of work, and the registry can't decide themselves. That's the worry.
Lordships, it was a very small matter. Lordships asked me to put the hypothecated certified copy of the vehicle documents with 100%
We will
hypothecated.
see, check it up and see and get it listed tomorrow. Yes. Next.
I may be pardoned to mention, my lord, 482 application challenging the order of cognizance under the cognizance is taken under the Factories and Boilers Act, and the prosecution report has been filed after 3 months. On that ground,
Oh, merit, don't say. You give it.
Man.
It will come serially. There is no.
it's a result of
Basic
222.
urgency.
Pardon to mention, my lord. Petitioner who has the husband has filed this case challenging the DB case before
What do
the.
you want?
I want to posted it for in this week, any date of this
So
week.
it will come serially. There is no.
I beg your pardon, my lord. If your lordship remember, I am in virtual mode. I'm extremely sorry, my lord. I'd mentioned, your lordship was kind enough to allow my prayer for interim bail because a lady is suffering from cerebral disease. So on that ground, your lordship, we
Yeah, I'll
can't
tell
allow.
I'll tell you the problem is there are about 30-40 matters interim bail.
I understand, but your lordship.
No, this is again, it's misusing. And if I find that any interim bail application is filed mischievously or whatever.
Yes, my your lordship. Yes,
I'll
lord.
dismiss the main petition also.
Yes,
That's
lord.
for
Yeah,
sure.
yes, lord. I have, your lordship may call for a report with
There
that.
was no application nowhere. All of a 30 application comes to the court. Every day.
Your lordship was kind enough to allow my prayer week back, my lord. I was expecting
fine.
last week it was not.
The interim prayer wherever. If there is a case of death, then only we list. Otherwise, everything will come serial.
My lord, because we are health ground, my lord, we are seriously ill, my lord.
We'll see.
Your lordship was pleased to allow my prayer in the last week.
Then,
Same case I am mentioning, because it does not come, my lord.
It will come. You give the number. we'll see.
BLAPL 5268 IA 974 of 24.
Yes.
Pardon to mention, your lordship, CRLMC 1829 of 24.
Sorry.
CRLMC 1829 of 24 was to come on 28 2024, your lordship. Has since then
Those
been not
matters will
listed.
be spread over in this week. Yes.
Pardon to
Okay.
mention, this matter was directed to be listed today, regular bail application, but the date was fixed today. So pray any
I
day,
have fixed the date.
not coordinate bench.
Now it will come in serial.
He's in custody since May.
Because
that is
the other bench might have adjusted his board.
only
accordingly.
a short date. If
And
your
I have to
lordship may
adjust my board.
lordship may fix a short date.
Well, he'll do it. Wait for 10-15 days, all the matters will come.
Obliged.
I'll try to increase the number of bail application by tomorrow. Tomorrow we will increase. Today I have taken 36. Tomorrow I'll try to take it 50.
Obliged.
And if you cooperate, definitely. Otherwise, see, I am getting it listed and many of you come and ask for adjournment. That's the whole difficulty.
A small prayer, your lordship.
Yes.
A conviction by the special judge vigilance, my lord. That is not a challenge, my lord.
Sentence,
Up to 2 years, my lord.
take it tomorrow.
Oblige, your lordships.
Well, pardon to make a mention, my lord. My lord, CRLMC number 2201 of
Yes, yes, tell me
2020.
what you want.
My lord, we are praying for quashing of affair during Borgar PS case number 59.
It's all right. What do you want?
Kindly the matter may be
It will
listed.
come. Yes.
Permission to make a mention, madam.
Yes.
This is a bail application. The petitioner is in jail custody since 1st May 2024 for offences of 420, 465, 1OTB, 34 IPC.
Tell me what do you want? You
The
read
listing
the
of this-
entire IPC now.
The listing of this matter. Minor.
It will be listed. Why do you worry? Give it.
Obvious time.
Pardon?
Bail would have seriously. Actually, dahle manage kariyo. Otherwise, there is no point. Then 482s will remain. And regular matter is completely stopped. You have to balance everything. 50 I am trying on. I can't help it. You see how much one court can take. And you know you sit here, then the type of assistance you will get.
50 meters, I think.
50 meter will try. 36 today we have taken. The problem is there are specific adjournment matters also. 10-15 matters specific adjournment, and thereafter the other about 30 matters. Beyond that, it's not possible because 482 will get stuck. Because the amount of the number of cases filed, at least the same amount of cases are not disposed of and getting piled up.
Lordship can fix dates.
No, that also I have tried. That doesn't work. That doesn't work. Doesn't work. Let us see. I'll try and try to get listed about 50 matters. Can we try that? Then fixed.
सोमवार मंगलवार बुधवार बेल कर दियंतु गुरुवार शुक्रवार अपील आउ फोरेट कर दियंतु सेमति करले बढ़िया
So I'll just see. I'll take your suggestion. I'll just speak to these people.
Pardon to mention the
You try whatever. If there is effective assistance, we can do.
Fresh admission ହେଇଥିଲେ fresh matter ହେଇଥିଲେ ହେଇଥାନ୍ତା ଯେହେତୁ urgent matter ଗୁଡାକ ତେଣୁ date fix ହେଇଯାଇଛି
It's a problem.
जोगुडा को डेट फिक्स है सेडा प्राय सब सोमवार मंगलवार बुधवार ही फिक्स है प्राय
I'll just check it up. Let us see. Yes.
Pardon to mention, your lordship.
Item 6, today list, not.
Not first. Today 6.
And another item 17, wait for 2 weeks.
Wait, 17 will come. Wait. Yes.
Pardon to mention, your lordship,
Yes.
may be permitted. CRLMC 3158 by 2023. It was directed to be listed on 28/3/2024. Has not come since then.
This will come. All the matters are those matters which were supposed to be listed Friday and Saturday will be spread over in this week. Yes.
No, my lord. It was on 28th March.
It will come. Yes.
Pardon to mention, my lord.
Pardon to mention,
Serial number 56.
1 minute. Online.
I beg your pardon to mention. I'm appearing through virtual High Court Sambalpur for Mallards. It is with respect to item number 89, Mallards, listed today. Mallards 89. There is a interim application, Mallards, for stay of the proceeding before the Learned Trial Court. The application was filed in the month of April, Mallards. And the
What do you want?
I want the at least interim application may kindly be.
Wait, let it come. Why are you worried? Let it
By
come.
the end of the day, my Mallards, my humble submission.
No, the matters will start from 85. 85, no? 85 1. Okay. Wait, it will come. Don't worry.
I may pardon. Item number 5, permitted withdraw only.
5 withdraw.
Pardon, my lords. Pardon.
Give the memo, Mr.
Pardon.
Mahapatra. Please give a memo.
Again.
Pardon to mention, my lords. Item 4, may I press for an adjournment, my lords? There is a medical emergency, my lords. For that reason, my lords. Item 4 may kindly be adjourned.
Put it after in the November.
Pardon to mention, my lord. Today, my lord, serial number 56, my lord. On behalf of it, late Mishra, my lord. I filed the middle.
You are for petitioner?
Again.
Who is after notice? Interim order is there?
No, my lord.
Adjourn.
56.
Interim order is there? Adjourn. All this matter will come in November, huh? Not before. No. I have adjusted the board and you, all of a sudden come ask for it. It will go November. Anybody is asking adjournment, put it in November.
Item 3, my lord. I have to file the copy of some documents, my lord, but keep it.
Yes. Adjourn. Yes. 85 first. Okay.
3, yeah? 1.
Yes. Yes, madam.
Yesterday still I could not contact, but today morning since it an advocate brief, I talked to that advocate and he said that he had also with a discussion with the petitioner, he said that on before 6 it's not possible for to reach because since due to involvement in this case he has ousted from his earlier.
We are not under the mercy of the accused. If you come, then I'll pass.
No, on 6th he will, because since the date is fixed to 6th in the mediation center, on 6th he will reach. On 6th, but it is not.
Have you given 10,000 rupees?
No, 10,000 I have given the account number, he will deposit back.
Okay, 6. The mediation, date of mediation is fixed on 6th. Awaiting mediation report, release the matter after 6th.
Yes. Interim order may kindly be
to continue. Yes.
Grateful.
64. 64. Death case.
64. Yes, death case. 64. Take out 64. Have you verified, Mr. Raman? You verified?
5215. Verified.
Death.
USA Consulate General issue question.
The petitioner has moved an application for an interim bail. IA number
1131.
1131. On the ground that his father has expired.
No. Nephew of petitioner number 1 died.
Second.
IAC
Golanthara.
Nephew of petitioner number 1. This is what? Prabhakar Reddy.
Yes, Prabhakar Reddy.
Who died?
Nephew of petitioner number, only nephew, my lord. Died in USA and body came yesterday night.
Yesterday came
Do an application on the ground that his nephew has passed away. They're in USA.
USA.
And the dead body has been brought to Orissa.
Yes, yesterday.
He seeks an interim prayer, interim day to attend the rituals. Rituals. The IIC Golanthara PS has submitted a report after verification with the link regard being head to the aforementioned, the petitioner shall be released on interim bail for a period of 15 days.
Yes.
For a period of 15 days. The trial court is directed to release the petitioner on interim bail for 15 days on such condition being fit and proper. And the petitioner is directed to surrender before the jail authority on 15 days.
15 on 16 on or before 16.
20th. On 20th.
No, my lord, your lordship may say on 17th, your lordship.
17th. 17th of September. And furnish the report before the surrender report before this board. Okay.
My lord, your lordship may
the matter after October.
Your lordship may say list this matter along with BLPL 5199 of 24
along with the BLPL 51
on 20th, my lord. 20th September.
Don't give the date. We will see. Yes.
5199 of 24. 307 again. 6 months royal co-accused released by the court.
Released it immediately. After 20th.
20th.
Next week, 23 wala week.
Instruction, my lord. Actually, mention the instruction, my lord. BLPL 5205, that is 5215.
Yes.
5 yes.
Your lordship may say
05 Again, he will not come out.
My lord, may I say petitioner number 1,
Petition number 1, huh? Yes.
copy in course of the day.
Just now, you immediately do that. Yes.
Item 1.
Wait, please, my lord.
Yes.
My lords, the FIR has been registered on the basis of a 1cc case with offences under section 341, 294, 363, 506, 34 and 6 of the POCSO Act, my lords. My lords, in the meantime, opposite party 2, who is the informant, and opposite party 3, who is impleaded, the victim herself, the petitioner and opposite party 3 have been married and are blessed with a male child, my lords. The part.
If you
female
notice.
child, my lords. My lords, the petitioners of the parties are present, my lords.
But they are married.
My lords.
Mr. Biplab Kumar Das appearing for the OP2.
Yes, madam. I am for this.
Have you filed any marriage certificate or anything?
No, my lords. Well, I have annexed the doctor reports and the antenatal cards, and all the details have been filed at Annexure 3 series, my lords.
Annexure?
3 series, page 21 onwards.
What have you filed?
The antenatal cards of the post-pregnancy card. All the reports.
What was the age of the girl?
My lord, at the time of incident, she was
17 years.
17 years.
The boy?
Boy is
25.
my lords.
Yes, Mr. Raghunath.
Order, that is true, but in fact, my lord, whether charge sheet has submitted or not, that is the during investigation, my lord, they have only filed the FIR.
We're challenged we have
Charge sheet has
No, charge sheet has been filed.
Issue.
Issue notice, because who is the informant? Who is the informant? Mother.
no, my lords. Father of the
Father is there.
yes, my lords.
And daughter is also there.
They've come with the child.
You just seek instruction.
Whether charge sheet has submitted.
Charge sheet.
There are personal appearance may be, my lord.
Right on. Petitioner is an accused. Who is the petitioner? What is the name? Chandan Kumar Das. Chandan Kumar Das. And the victim is?
My lord. Victim is
Who is opposite party number 3?
she's the victim, my lords.
No, Ramesh Chandra.
Ramesh Chandra.
Who is he?
Ramesh.
Opposite party number 2 is also Ramesh.
Yes.
My lords.
Why have you implicated Ramesh?
My lords, there's been a mistake. I beg apologies, my lords.
Who is Ramesh? Ramesh Chandra Manna. Ramesh.
Ramesh, he's the father of the victim, my
Father
lords.
in-
It submitted 6/8/12.
6/8?
6/8/12, Lordship.
Yes.
Cognizance was taken on 6/8/12, Lordship, on the same date. The petitioner was admittedly on retired from the service before the charge sheet was submitted or the cognizance was taken.
Yes.
My lord, there are 5 accused persons. In the respect of one accused person, Itisri Mahati, your lordship, coordinate bench has already quashed the cognizance order. Itisri Mohanty, lordship, it is CRLMP number 1174 of 2015.
Yes.
So the vigilance proceeded erroneously on the impression that the cognizance sanction is not required, since in the meantime he has been retired. What are the 2 issues I am raising before your lordship? The post-launch proceeding, after post-retirement launch proceeding, sanction is.
Show me if you have a judgment.
Your lordship already held in the judgment. Your lordship's judgment. Would have been.
Have you given just see whether you covered all this judgment?
No, I have not gone through your lordship's judgment, but.
Lordship, para 9, lordship.
But I have the.
Para 9.
Para 9?
Yes.
Since the legal position is abundantly clear,
yes,
that even if the prosecution is launched against the government servant after the retirement, the sanction is essential. The court has committed an error by taking cognizance of the offence and also without valid reasons. Moreover, this court, while allowing a similar type of prayer made by co-accused, was he is one of the co-accused.
No, lordship is different case. Thus, I am placing the ratio. Lordship, the post-retirement proceeding pre-amended act.
Chittaranjan Das.
Yes.
Chittaranjan Das, Super Chittaranjan Das is in that case, sanction was once refused, after retirement again sanction.
No, but that case says that sanction is necessary. Let's see.
Sanction is
Preceding
necessary.
paragraph.
I have-
We are of the opinion that in a case in which the sanction sought is refused
Huh.
by the competent authority,
My lord.
while the public servant is in service,
My lord.
and he cannot be prosecuted later
After his retirement.
notwithstanding the fact that no sanction for prosecution under the Prevention of Corruption Act is necessary
My lord.
after the retirement of a
My lord.
public servant.
There-
Any
yes.
other view will render the protection illusionary.
Huh.
Situation may be different when the sanction is refused, the competent authority,
My lord.
the retirement of the public
My lord.
servant.
Here is
That
the
is, that is not the case here.
I am telling that case, sanction was refused. What the trial court did, trial court erroneously proceeded since in the meantime retired, irrespective of the sanction refused or granted.
In your case, sanction is refused.
No.
Sanction is not refused, but the pending sanction, Lordship kindly see the order dated 8/2/2024.
8/2/24.
They have opted the sanction prior to the cognizance, Lordship, recently, but it is not culminated till that. The 86-year-old man, how long he will suffer, Lordship?
So far law is concerned.
Lordship kindly say 8/2/24. The instruction was sought for.
No, this is the counsel the petitioner further
Memo.
contended that in view of the amended provisions of 19C of PC Act, even after retirement of the accused, if the offence is alleged to have been committed during his service period, sanction is an essentiality.
Essentially, Lordship, last paragraph here, Lordship also.
Essentiality. However, Mr. Maharana, Lena Counsel for Vigilance submits that the amendment was carried out in the statute after the cognizance in the case is taken with Lanka, so and so. The counsel for the petitioner in the bunch of document today to show that the steps were being taken at the department level for the purpose of obtaining sanction to be placed before the court below. So however, it is not finally terminated into the sanction order. Therefore, he submits that on the basis of the document. What are the basic documents you have?
Already the record was not supplied.
Then attempts were made by the prosecution for getting sanction.
Yes.
Sanction was not granted.
Not granted.
Then at that stage he retired, and cognizance was taken. And thereafter this amendment has come. What he says is the amendment, by the time the cognizance was taken, that time this amendment was not there. So you are not covered by it. And Chittaranjan says that if the sanction was refused but during the service period and subsequently
after retirement,
case,
waiting. The idea is sanction is refused. The prosecution is keeping waiting for retirement. Once the he retires, prosecution starts. That is the idea of Chittaranjan.
Yes. The Lordship, they have not obtained instruction till then. Lordship, I am supplying.
You seek instruction in this.
So far as it's a point of law, your Lordship kindly.
No, when you seek instruction, see the only one issue is, is it the case that you had repeatedly attempted to get sanction and ultimately it could not be culminated to a sanction order?
No.
Your attempt has been failed. Thereafter, immediately after retirement.
So far, I think so far the petitioner's case is concerned. So far, Itisri Mahanti, my learned friend, is relying. I was conducting that case. Perhaps the department has moved to the Hon'Ble Apex Court on that case. And so far, this petitioner is concerned. Sanction is not required at all in view of his retirement. Number one. Number two, so he has not given the file the charge sheet. I do not know why he has not filed the charge sheet. Even he has sought for quashment of the proceeding. And law is very clear. Relying all the judgments starting from inception, the Hon'Ble Apex Court in 2020 held that. So 2 points was there. One was whether in PC Act offences after cognizance is taken. That was two issues. One in 19 and 97. One so far as 19 is concerned, constitutional referring to the constitutional based judgment, this Hon'Ble High Apex Court has held that at the time of cognizance, if petition is retired and sanction has not been sought for, then and sanction is not necessary. So far 19 is concerned.
That is what I am saying.
My lord.
Where is the quarrel on
So
that
far as
point?
this petitioner is concerned,
Whether
that is not sanction has not been sought
Para
for.
5 of my earlier order, just see. Then counsel the petitioner has filed a bunch of documents today to show that steps were being taken at the department level for the purpose of obtaining sanctions to be placed before the court below against the petitioner. However, it has finally culminated, it has not finally culminated into the sanction order. Therefore, he submits that on the basis of the document he has filed, the prosecution launched against the petitioner is an exercise in futility and seeks indulgence of this court. What he says is, you have attempted to get the sanction which you failed. These are the documents he's given. Why don't you verify?
Memo already supplied. On 8th memo supplied.
He has filed.
Directed to take instruction.
Mr. Marana, land counsel for the petitioner, seeks 1 week adjournment to seek instruction whether the prosecution had indeed attempted to get sanction from the competent authority to prosecute the petitioner and failed to get sanction order from the competent authority or not. Leave the matter. You get the instruction. Yes, fine.
30th.
And
second,
give those judgments.
Yes. Second,
After 18th.
so far second case is concerned.
Yeah, second case.
Second is the issue is the same, Lordship.
No,
Issue is
issue is different.
Huh.
They issue their sanction is not at all necessary because your lordship kindly see the order. They are challenging the cognizance order of 2012 in 2000 and he has.
Well, anyway, both the matters are here.
And the same, Lordship.
And
I will have.
most important thing is he has suppressed the material fact regarding earlier rejection.
Then I will not interfere. Be sure about it.
I'll take.
Yes.
Pardon, my lord. I may be pardoned, my lord. Item 28, interim bail, my lord. The father of the petitioner has been expired yesterday, my lord.
You should have come in the morning.
My lord, that is my pardon, my lord. I bow down before
But
your
there
lordship.
should be some decorum also.
Yes, my lord.
Not that whenever you want.
No,
you come back,
it's
that
my
pick
part,
up your
my
matter.
lord. I bow down.
If it is so urgent, you should have been there. I was searching rather.
Yes, my lord. Yes, that is my fault, my lord.
Yes. Right on. Petitioner has moved application 28. I number?
I number, my lord, 1138 of 24.
No.
No.
I number of 547 24. I number.
I number go 113.
Sorry, I number.
I number 1138.
I number.
Right on. Petitioner has moved the present application seeking interim bail on the ground that his father has expired on
Yesterday, my lord.
1/9/2024. The IIC Baliko, the PS, has submitted a report in this regard, which reads regarding to the fact that the father of the petitioner has expired on 1/1/2024. And the petitioner petitioner has to attend the rituals. I'm inclined to admit the petitioner on an interim bail for a period of 15 days.
1 month, my lord. 1 month.
1 month.
15 days.
15 days, 20 days. 20 days. 20 days. 20 days. The trial court, the court in session is directed to release the petitioner or interim bail on the condition being fit and proper. So the petitioner is directed to surrender before the jail authority on or before 25th of September.
My lord.
25th of September and file the surrender certificate before the court, release the matter thereafter. Yes.
May I please pray, my lord? In course of the day, I'll
Like, course of the day.
Yes.
Subject to condition if you have a pleasure of coming to the court.
No, my lord. I bow down, man.
Yes. Next.
Item 7.
Yes, 7.
May I please?
Main bail is urgent, huh? Yes.
May I please? The pick.
It be easy to matter. Yes. Yes, sir.
Cognizance has been challenged, my lord.
Yes.
Kindly peruse Annex 2, Annex 3, page 18, the injury report. Bruise injury and simple manner. The petitioner, the opposite owner to the informant being an advocate.
307 is not made out.
Yes, my lord.
Then you have to argue on charge.
Yes, from that liberty.
Right on. counsel for the petitioner submits that in view of the injury report, no case under section 307 is made out. Therefore, he is assailing the cognizance order passed by the court below by the impugn order dated 10/2/2023. I'm not inclined to entertain this petition. However, the petitioner has given liberty to urge all these points before the court below. Charges, if such points are with this liberty, the petitioner is supposed to. Yes, next.
8. On behalf of Amlan, taken a 1 week after my lord. Item 8. 8.
Adjourned. November, November. Yes.
Item 9. Password.
What is this matter?
I don't know.
My lord,
On behalf of Mr. Cha.
my lord, is challenging the 337 CRP's petition, my lord, under section 302, my lord.
Let him talk. Yes.
Item 10.
May I please?
Yes, sir.
10. I am challenging the order of cognizance.
Sorry?
I am challenging the order of cognizance.
Yes. Ground?
Ground, my lord. I am the son of the principal.
Son of-
My career has been lost. I am not named. Some property has been acquired in the name of mine, my lord. For that reason, the department has charged it against me. I am a MBA student. I was working at Bangalore. Some property has been, my lord, acquired my father. During the my name. That is the ground, my lord. Already my career has lost for this reason. The vigilance department.
Are you claiming that these properties are
Yes,
acquired by you?
my lord.
Then-
No, my lord.
What is your case?
Some property has.
Is it your case that all these property which is acquired in your name?
Some is
are the property of the father? Are you saying that?
My lord. And apart from that, my lord, though I am a government MBA student, my lord, I am serving at Bangalore.
No, the question is,
My lord.
109 will not come in your way
My
if you don't have a separate defense. If you have a separate defense, then you have to prove it. That's
My
the
lord,
law.
my lord.
Do you have a separate defense?
Yes, my lord.
Then you it will be tasted in the trial.
Page 55.
55. Yes.
Last two paragraph. Last two paragraph.
All the above, please.
All the above. His son Tusharkanta Meher, petitioner, took plea that he has earned the landed properties from his salary income and from agricultural income, as he had taken land on lease during the year 2008 for 5 years when he was a student.
Then
And
you have to prove this in the trial. You have to prove this in the trial.
My lord, your lordship kindly have glanced. The occurrence, my lord, the affair has been what they have stated.
I can't pass it. Why you?
My lord, the career of the boy is
Maybe
spoiled.
career, but you are saying that I have acquired this thing being a student also.
They have
If
written,
you-
my lord.
if you would
Where
have
is my
said-
statement, my lord?
If you would have said that all these properties, my father, go and ask my father, then you are out. Because you have nothing to prove. Your father would have
If that would have written, then they would not be charged sheeted, my lord.
No.
My lord, my lord.
109 will not come in your way.
I am on 120B, my lord, not 109.
Oh, 120B also.
Same.
Huh?
Same.
Kona
The gali dobar. Same thing, say. Then 120B the ingredient that is also.
ଆଜ୍ଞା ଏଇଟା ଭାରତ ବର୍ଷରେ ଆପଣ ଏଇ ଭିଜିଲାନ୍ସ କେସ୍ ଏଇଭଳିଆ ଦେଖିଛନ୍ତି ପୁଅ ନାଁରେ ବାପା ନାଁରେ
I write like this, Bharat Varsa ଏମିତି ହଉଛି କ୍ୱାସ୍ କରିଦେବି.
ଆଜ୍ଞା
I have to go by law, sir.
yes sir, for that reason I am saying, my lord,
You,
I am your lordship kindly have glanced the check period time. Check period time is, my lord, since 1986 to 2016. 16.
What were you doing that time?
I was in job at Bangalore in the year 2016. I was not born in 2086 because my father is also not married at that time.
What was your father doing?
My father only accused, my lord. He is, my lord, banking assistant, district Central Cooperative Bank Limited, head office.
You are working as a clerk in a Central Cooperative Bank. You have assets of about 2 crore.
One DA one.
My lord, I do consider this, my lord. My father is acquire illegal property. I do consider. But
And
what
you
the
are trying
source
to
of
justify
income through
your
me.
right.
This
A petitioner is agreed by the order dated 19/12/2023, whereby the cognizance of offence under section so and so has been taken against the petitioner by the special judge vigilance Balangir in connection with the Sambalpur vigilance PS case number 78 of 2016.
can I file a
After
affidavit, my lord?
After investigation, the charge sheet has been filed. The charge sheet indicates that the present petitioner had taken a plea that he has earned the landed properties from his salary income and from the agricultural income, as he had taken land on lease during the year 2008 for 5 years. The agricultural income from the lease land and the salary income of the petitioner has been taken towards the income of the main accused. Since the petitioner has a separate defense regarding the acquisition of the assets which has been which is being alleged as ill-gotten money of ill-gotten assets of his father. This aspect has to be elucidated in the trial itself. Therefore, at this stage, this court cannot give indulgence to the petitioner. Hence, the petition is dismissed. However, liberty is granted to the petitioner to raise all the points at the appropriate stage before the trial court. With this observation, the petition is disposed. Next.
Item 11. Item 11 may seek a passover on behalf of Mr. Roy.
Passover?
Your Lordship.
Passover, same way that Kalias.
My lord, let it be passed over, Your Lordship.
You have any problem? You have any problem? And can it be adjourned because he has some personal problem, Mr.
Tomorrow?
Mohana? Let
Tomorrow?
it be after 18th. He
My lord,
has some medical issue.
My lord, let it be tomorrow, my lord. My lord, let it be tomorrow. He's looking for tomorrow, my lord.
Tomorrow, my
Same
lord.
issue, same issue जोटा decide कलो same.
Which is?
Same issue जहाँ decide कलो सीटा. एबे जोटा थिला same.
Pension.
Wife.
Wife.
हाँ madam.
My lord, may I just request Your Lordship, my lord, I am not prepared with the brief. My learned senior.
Friday asuna no? Friday.
Friday. Okay. Right. Yes. Next.
Item 12.
Should I prefer Passover?
Yes.
Item 13.
Yes. 13. Yes, sir.
13, my lord, here the final report was submitted.
Hmm.
That is on 36/22, final report was submitted as false. Then the court has issued notice to the informant. If there is an objection, otherwise we will accept their final report.
Hmm.
That notice he has challenged. That notice is in the year 2022. That notice he has challenged.
The informant.
My lord. That is the informant that the accused he has challenged.
Accused.
Notice was issued to the informant.
Oh.
That informant has challenged this.
Informant is challenged.
Challenge this.
The informant says that cognizance should have been taken. Instead of that, notice was issued.
That what happened if the
final report, final form is filed,
my lord.
then who is agreed? The informant is agreed.
My lord. Informant has not filed this. Accused has filed this petition.
The what right the accused has?
My lord, why the notice was issued to the informant to file any objection? That he has filed.
Password code, dismiss. Yes.
14.
Yes, madam.
Petitioner is a government employee.
Yes.
Allegation against him regarding 354 and the other offenses. That he has misbehaved with this co-workers. Initially, the complaint.
Harassment in the workplace.
Initially, the matter was referred to the harassment committee. The Lordship kindly come to case 37.
37.
Yes.
Yes.
He is a dubious character, everything is written, but the important fact I want to show to your Lordship.
Hmm.
See.
Hmm.
However, The one, Modinaji scene.
However,
However,
this
these
info.
no direct relevance to the present complaint and cannot be proved either. That was the finding of the harassment committee. After this report was submitted, 7 days thereafter, she has lost the FIR.
Okay.
Incident took place in 5/8. She lost the FIR on 22/8. And the report is in 15/9. He has reported the matter on 22/9, my lord. After
22/9,
Yes.
1.5 months. now.
What is the stage charge sheet filed?
Cognizance was taken. Cognizance on 30/11/23 cognizance was taken.
Issue notice, sir.
And 14/5/24 perhaps notice was issued, my lord. 14/5/24 order, my lord.
Notice was issued already.
That's right.
Because due to shortage of postage stamp, the notice on opposite party number 2 could not be served. Requires the counsel for the petitioner to take appropriate step for the purpose of serving notice on opposite party number 2. List them. Yes, next.
Within a period of 3 days.
3 days. Yes.
And my Bray Malady and also the initial stage have not granted me stage.
You-
Tribal offense, my lord.
That's right. You should have served. I would have decided on merits.
Why not they kill?
No.
Or
This,
they kill him.
no, you should have been careful. Notice is issued. You are very casually cheating.
The noting we are seeing.
I don't know, but I can't help it. Ex parte order. Yes, next.
Okay, I think they fix for the date fix for.
The date fix करिए. Date fix करिए. After 2 weeks, date fix करिए. Sir, immediately so that letter come.
Okay.
We'll see. She may not be interested also because the harassment committee has given a report in your favor. And see, incident in 5/8 harassment committee harassment committee gives a report on 5/9.
15/9.
15/9.
She lost the FIR on 22/9.
22/9. So therefore, in between this harassment committee report has come. So you may have a point to argue. 354 after all. The harassment committees are only meant because immediately the harassment committee takes the cognizance of it and inquiry into it. So therefore, it has a relevancy. And harassment committees are statutory committees. These are not the committee casually formed. It is under the statute it has been formed. So it has an impact. Otherwise, what is the use of the statutory committees? After judgment of the Supreme Court, there was a law and committees are constituted, Vishaka. And these committees reports has to be taken into consideration. Police can't routinely file it. You have to take into consideration the report of the committee. And sometimes it happens otherwise. The committee says that there is harassment and police file a final report. This is also happening. Then you are giving completely go by to the report of the statutory committee. Then I'll decide whether what is the impact of a committee report in the investigation process.
Yes, madam.
Yes. And if that law is settled, many problems. So therefore, I'm interested. You assist me on that. What will be the impact of a statutory committee report created under a particular statute on the university?
That to my lord, act that came into force because of Supreme Court judgment.
Yes, Vishaka judgment. Okay. Next.
15 दिन पर उन्हें time टेबल देवे.
Giving yes.
May I please, madam?
Yes.
The petitioner has not been named in the FIR, but subsequently charge sheet has been filed. The petitioner has filed discharge petition, and the same was rejected by the learned article session judge. My lord, the petitioner referred bail application before this honorable court. Now kindly have a glance to page 17, para 7, my lord.
Yes. 7, huh?
Para page 17, para 7.
Yes.
On perusal of the same, it is seen that only allegation labeled against person is that at this instance the offence has been committed. But there is no material that the petitioner has nexus with the crime And the page 20, the rejection order passed by the learned additional session judge.
Do you want that the observation made by the coordinate bench while granting bail should be the ground for quashing the FIR?
No material against the petitioner. And the learned session judge has also held that had instigated the co-and also he had made
Show
conspiracy.
me the charge sheet.
My lord, charge sheet copy. I'm not annexed.
Which part? You have instigated, that is the instigated is not a crime.
Instigated is
crime. What to do? Right off. The petitioner has said you raise all these points at the appropriate.
My lord, discharge has been rejected.
I know what to do.
Ma'am, discharge
There are allegations.
let it produce the CD.
See, why CD? There is nothing.
No offense is made out.
It's made out. I have read it.
Only
You have not filed charge sheet, that is the reason.
no.
Because once the charge sheet is read out, then offense is made out.
Only against the present person that.
That's enough. You have instigated for commission of the crime. That's very specific allegation. That has to be tested in the trial only. How can you be discharged? Shall I erase that by putting cancelling that few lines which are against you? Court can't do that at this stage. Petition is agreed by the order dated 16/3/2024.
If the only had instigated active person.
Podola, Ganja in
But I may pardon my lord. I pray my lord. Not pressed, raise all the points.
That's what I'm saying. Podola in session style number 15 of 2023, whereby his application under section 227 CRPC for discharge has been rejected. And then counsel for the petitioner submits that he would not press this petition at this stage. However, reserving his right to raise all the points at the appropriate stage before the trial court. The liberty with this liberty, the petition is disposed. Yes.
16.
Your Lordship, in item 16, this is a CBI matter, Your Lordship. On behalf of Mr. Sarthak Naik, I'm praying for a short adjournment, Your Lordship, in the matter.
I'm for the petition. No problem.
On behalf of the counsel for the CBI, is a request for an adjournment. Adjourn the matter.
In the meantime, my lord, I will file an application for adjournment before the learned court. That may be considered, my lord.
Counsel for the petitioner submits that he would seek adjournment before the trial court by moving appropriate application.
Okay, my lordships.
17.
Yes. What is this?
Yes, sir. Let's see, have a glance to page 26.
26. Notice was issued.
What a
On a
compromise.
the petitioner. Nobody appears. Last time also nobody appeared. Right, when the matter was taken up on 15/5/2024, none appeared on behalf of the petitioner. However, the matter was adjourned for today in the interest of justice. Even today, none appears for the petitioner. It appears the petitioner is not interested to prosecute the present case, hence dismissed. Yes.
18.
So disposal.
Yes.
About the condition of 5 lakhs.
Sorry?
About the vehicle has released, my session judge has allowed the petition for releasing the vehicle with the condition that 5 lakhs bank guarantee or bank draft. That is the law. That is the law. 2021 गाड़ी रिलीज ऑर्डर है नहीं करना 24
5 lakhs was the condition of bank guarantee.
Bank guarantee or
bank.
Then 21 release direction नहीं problem. 27 financial condition.
Not released.
Not release.
Which vehicle is this?
Tata Magic.
Tata?
Magic. There's 15 now.
Right, by the petitioner is agreed by the order dated 16/9/2021, passed by the additional sessions judge Jharsuguda in criminal division petition number 21 of 2021, whereby although his the application under section 457 CRPC for release of the vehicle Tata Magic Express 9+D BSIV bearing number OD-23-K-2422 was has been directed to be released. However, there are conditions that he shall furnish bank guarantee of 5 lakhs or a bank draft of 5 lakhs. Then counsel for the petitioner submits that although the order was passed way back in 15/9/2021, however, due to the constrainty, the financial constrainty, he could not arrange the funds to furnish the bank guarantee. Therefore, he seeks indulgence of his court for variation of the said condition. You go to trial court. I am giving the opportunity. Yeah? I am not inclined to entertain this petition.
Incorporate
because
the
petitioner has not
insurance
opposed.
components.
Huh?
He should incorporate the insurance company, then only.
The petitioner has not moved the court below for seeking variation of the said condition. The petitioner is granted liberty to move appropriate application before the court below, seeking modification of the condition of release of the vehicle in view of the fact that despite the order being passed long back, he could not arrange the finance to mobilize the conditions. If such application is moved, the same shall be considered on its merits after putting the insurance company, insurance company and the other concerned to notice. With this liberty, the petition is disposed of. Yes.
19.
Order taking cognizance is under challenge. Permitted to withdraw to raise all the points by filing discharge petition, and the learned STM shall here then pass report.
Counsel for the petitioner seeks to withdraw this present petition to raise all the points that have been raised in this petition before the court below at the time of framing of charges.
By filing discharge petition.
By filing appropriate
Discharge petition.
Seeking discharge. If such application is moved, the same shall be considered on its merit. Yes.
20.
Yes.
May I please your lordship?
Yes.
For passing of cognizance, my lord, on basis of amicable settlement between the parties, my lord. Opposite part number 2 is the informant here.
What are the offences?
Offences, my lord. Running page 16, your lordship may see.
376.
498A, 498A, 366, 366A, 323, 506.
366.
Charges submitted, my lord.
498A.
498,
360,
with 4 DP Act,
320,
with 4 and 6 POCSO, with
6 books.
All.
3 SC/ST Act.
That's married already. 498A is there, must be married. Isn't it?
My lord.
What is the settlement?
Settled, both the, but the girl has already got married somewhere, my lord.
Somewhere else.
My lord.
Then where is 498A then?
They got married, resided for 3 months. Thereafter, the disturbance taken place.
Oh, she is a minor.
What
kind of marriage?
My lord, by that time, 18 years.
Initially, FR was registered against the present petitioner in an offence under section 341, 324, 307, 34 of the Indian Penal Code. During the course of investigation,
cognizance.
31A notice was issued to the petitioner. He was
Before submission of charge sheet, my lord.
during the course.
How does it have a bearing? 41 given or not? Cognizance order, you tell me.
My lord, police submitted charge sheet against the present petitioner in an offence under section 341, 323, 34 of the Indian Penal Code. 307 was not against the present petitioner. Cognizance was taken and summons was issued. And in view of 307, the petitioner could not surrender. In the meantime,
Okay, you want to surrender.
surrender.
41 notice was given.
My lord.
307 is added.
Correct.
Subsequently.
My lord.
Right on. Land Council, the petitioner has challenged the order dated 30th November 2023 passed by JMFC Dasapalla in GR case number 396 of 2023, whereby cognizance of offences under section so and so 27 is taken against the petitioner. And counsel for the petitioner submits that although in the FIR the offence under section 307 was 307 FIR was there.
But,
Yes, FIR was there.
Your lordship may
Charge
see
sheet.
running page 25.
No, although
25.
implicated, but the petitioner was given notice under section 41. 41A. Subsequent thereto, the charge sheet has been filed and cognizance has been taken. He apprehends that pursuant to the summons issued by the court below, if he appears, he may be taken into custody. This is apprehension to allay his apprehension. I am not inclined to interfere with in this matter of this case. However, liberty is granted to the petitioner to surrender before the appear before the court below on or before 30th of September 2024 and avail remedy under law. Under law, he may move appropriate application seeking grant of bail by relying upon the judgment of those two judgments. वो जो अग्रवाल, सुशीला अग्रवाल and all. Right. This is what is the petition.
Till then, no pursuit. In the meantime, BW has been issued. Petition is a
Till then, till the petitioner surrenders, no course of action shall be taken.
Hon'Ble.
25th कर देते हैं, 30th नहीं, 25th को. 25th. Before 25th, you go and appear and move on a bail application relying upon the Sushila Agarwal and all. And you will be extended. Yes.
23.
May it please your lordship. This is an application under section 482 of CRPC.
Yes, sir.
For passing of criminal proceeding, my lord. The petitioners in this case are seeking quashing of successive FIR, my lord, filed by the opposite party number 2.
Yes.
My lord, may kindly see annexure 1, page 21.
21. Yeah.
This is the first complaint case filed by the OP number 2 against the petitioner number 1.
Kalpana Gupta.
Kalpana Gupta. Subsequently, by annexure 2, at page 40, she has filed another.
What was the allegation in the first FIR? First complaint?
Non-payment of, due to non-payment of rent, she wanted eviction from the rented accommodation. For that, she has also.
You are the tenant.
Yes.
She is the landlord.
Yes, ma'am.
Yes.
For that, she has also filed civil suit against me.
Eviction.
Yes. And in all these cases, except annexure 2, she lost the case. And cases were dismissed against her.
Now, what is where are the second FIR? Let us see second FIR.
Second FIR, my lord, page 40.
40.
Yes.
Yes. What happened to the first complaint?
First complaint is dismissed, madam.
Dismissed?
Yes, madam.
Then he files FIR.
No. During pendency of first FIR, she filed.
First complaint case.
Yes, yes. She filed another complaint in the same year, madam.
Okay. Issue notice to opposite party number 2, returnable we can quick.
Interim order, madam.
This can be, this is the landlord tenant dispute, it seems. Eviction suit is pending.
Civil suit is dismissed, my lord.
Dismissed.
Yes, my lord.
Why are you not vacating?
My lord, my clients are heavily misguided by the lower court.
You vacated the house.
No, I have already vacated the house,
Then what is the, what is
but the case is going on.
already vacated?
Yes, yes.
Then what does she want now?
I don't know, my lord. So,
Arrears of rent.
yes, my lord.
Arrears of rent.
Arrears are also paid. My lord. Arrears are also
You
paid.
said that her suit for eviction has already been dismissed.
Dismissed.
Then when have you
First
vacated?
complaint is dismissed. Second complaint is pending.
Well, the counsel for the petition submits that the opposite party number 2 on 12/7/2005 filed 12/7 or 12/8. So for this thing. Where's the date of filing the first one?
In the year 2001, my lord.
Right, on 20th.
Second one
April
is also 2001.
April 2021 filed a complaint against the petitioner, which was dismissed, Subsequent thereto, again for the same cause of action, he filed he or she filed another complaint which culminated to the Cuttack PS case number
PS case number 130 of 2001.
2001. The complaint case earlier filed and the FIR contains the same allegation. It seems the dispute is arising. Dispute is a landlord-tenant dispute. The petitioner is the tenant, and the opposite party number 2 is the landlord. The landlord counsel for the petitioner further submits that the opposite party number 2 had also initiated an eviction proceeding against the petitioner, which has been dismissed. Despite the aforesaid, the petitioner has vacated the tenanted premises and also paid all the areas of rent. In the foregoing circumstances, petitioner submits that the present proceeding initiated by the opposite party number 2, the landlord, shall be quashed. Issue notice to opposite party number 2, returnable within 2 weeks. In the meantime, the proceeding before so and so is yes.
Urgent copy, my lord.
Yes, next.
24.
Oh, bless.
May I please? For the limited prayer, my lord, the petitioner is opposed to lordship on the basis of petitioner's affair under section 430, 467, 471, 474, and 34 IPC. My lord, the police filed the charge sheet and the cognizance was taken by the 15/9/2017, annexure 2, my lord, page 11. Then, my lord, on 22nd
to page 11. This is NBW order something.
No, not NBW. 15/9/2007.
Okay.
17, my lord, the cognizance was
Where
taken.
is the charge sheet?
No, charge sheet, my lord, I have not filed. I have only prayed for early disposal of this case. Because
But I need to know charge sheet, how many witnesses are there, what I don't know.
No, witnesses, my lord, just lordship just turn to page 12. On 22nd/5/2009, NBW issues against the accused persons, and that is still continuing without execution. Without recoursing to the 82 of the CRPC provision.
No, what I'll do is you go and appear.
My lord, I am the petitioner. I have filed the affair.
But you are the complainant.
Yes, my lord, I am the complainant.
Why it's not executed?
It's not been executed till today, from 2019. So I humbly pray, lordship,
I will give a direction to the concerned police station to execute the NBW within a month.
Also prayed, my lord, from
petitioner-
2017 it is
okay,
pending.
okay.
Maybe
Petitioner
it was
is the informant.
My lord, I am informant.
Informant in the PS, Nayagarh PS, Ranpur, huh?
Ranpur, my lord.
Ranpur PS case number 55. What is it? 66.
66.
For 2017.
17.
17. Learned counsel for the petitioner submits that although the cognizance of the offenses has been taken by the court below on 15/9/2017, the trial has not proceeded an inch even today. Subsequently, on 22/5/2019, NBWs have been issued against the accused persons. The said NBW has not yet been executed. And even the proceeding under section 82/83 has not been initiated against the petitioner. Now, therefore, he aggrieved and prays for the expeditious disposal of the trial. Regard being head to the aforementioned, I feel it appropriate to direct the PS, which PS?
Ranpur PS,
Ranpur, IAC Ranpur, to take all necessary steps to see that the NBWs issued against the petitioner,
accused person.
accused persons are executed without fail within a period of 1 month hence.
If there is no legal impediment, we don't know whether in the state or not, it will be.
If there is no there is no if there is no legal impediment, there is no legal impediment.
And also, let's see, my lord, with a prayer that Ranpur, my lord, the sub-judge, that civil judge, Junior Division come, JNC Ranpur, may directed to dispose of the case at 6 months.
I don't know whether accused are there or not. How I don't know how many.
It's pending is
Right, let them come. See, we can't make a impractical target to the trial court. We can't go step by step. Let them come.
Yes, next. Urgent come.
25.
May I please, my lord?
Yes, sir.
My lord, I am praying for quashing of the cognizance order dated 22/12/23 under Annexure 1.
Yes.
My lord, offences are, my lord, under section 376, 511, 354A, 354B, 509,
Why should it be?
Because 376 is not made out here.
Then argue that a charge stays.
Yes.
Right. Petitioner is challenging the order dated 20th/12/2022. 23.
Yes, ma'am.
23. Whereby the learned additional sessions judge Kujango.
Yes,
has been pleased to has taken cognizance of offense under section so and so in PS case in GR case number, special GR case number 84 of 2023. The counsel for the petitioner submits that even if the allegation of the prosecution is taken at its face value, no case under section 376 IPC is made out. Despite that, the trial court has taken cognizance without application of mine. I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to urge all these points at the stage of framing of or charges. If such plea is taken before the trial court at the stage of framing of charges, the same shall be dealt with on its merit, on its merit. With this liberty, the petition is disposed of. Yes, next.
26.
My lord, here I may place all those things, my lord, regarding.
In cognizance says, how can I go into all these things? So I have given liberty. Go and argue all these things at the state.
Obliged.
Rather, you move an application
Obliged.
for discharge,
Obliged.
saying that no case is made out.
Yes, ma'am.
I have recorded that even if it is taken at face value, that's the law.
Yes.
Whatever allegations are made, whether some case is made out or not, that has to be seen. At cognizance, only prima facie they have taken the cognizance.
511 is there.
Yes.
Let it be. Yes. 26.
May I please?
Yes, sir.
Criminal proceeding valid on the ground of compromise valid.
Offense?
Offense 307 and other allied offense valid 326. And I have annexed the
I have annexed the injury report, my lord. The nature of injury has not been mentioned in the injury report, my lord.
Which part of the body?
The abdomen.
Huh?
Abdomen. My lord.
Weapon
Stab
of-
injury is there. Stab injury.
Stab
One
injury.
stab.
Who
Page
is-
20, my lord, injury report. Size of injury is 1 inch into 4 inches.
Medical report you have?
Yes,
Injury
ma'am.
report.
Page 20, my lord.
22. Grievous or what?
Yes, cheek dorsal is definitely reverse.
But nature of injury has not been mentioned in the injury report, my lord.
Then we have to take instruction.
Issue notice to opposite party number 2. Let us consider for the state to take instruction regarding the nature of injury sustained by the injured in the present case. Please the matter. Yes.
My lord, till then,
One.
interim order.
You move application, nothing left. Mr. Mishra, and counsel for the petition submits that you move appropriate.
Then your lordship direct over first hour, second hour, man. First hour, second hour order. Lordship.
You are not on bail.
No, my lord.
You are talking about quashing. Bring in them, I'll quash.
Oh, bless, ma'am.
What is the? I'll just come.
Oh, bless.
Bail matter, sir.
27 କାର?
Informant, my lord.
Take up opposite party number 3. Huh? Okay.
Oh, bless.
27.
May I please? Here the alleged offence is 498, 323, 406, 294, 34 and section 4 of the DP Act. I'll have a glance to page 8.
Custody?
Custody nahi hai, anticipatory. It was placed before my lord justice. Yes, it was
Assigned to me.
other coordinate code as because his concern, that's why it has been now before my lord.
Okay.
So for the allegation is concerned, it is alleged that the informant, my lord, being persuaded by the son of the present person, because the prisoners are the father-in-law and mother-in-law.
First case is on.
No, first case. Bhul dhori. 7680, 7680.
You are the husband.
Two application. Yes, well, two applications are before my lord.
7896.
Yes, 7896 is the husband.
Husband.
And the other one is the in-laws.
In-laws.
Father and mother.
Hmm.
And it is alleged that the informant, my lord, being a major girl, being persuaded by this petitioner of 7896, my lord, she went to the petitioner, the house of the present petitioner, who are the father-in-law and mother-in-law. And thereafter, my lord, with some reluctances, somehow marriage was there in a court through a court process, marriage was there. And thereafter, it is alleged that some money was given by the father of the informant. Thereafter, some dispute, family dispute, and so for which he left the house and now lost the affair. But fact remains, my lord, because the fact that some of after the marriage, it didn't turn
What
up.
is the stage of investigation?
Completed.
My charge sheet has been already submitted. But I have not obtained the case diary, my lord. In
This
fact,
is
my
the
lord, the
affair.
second case diary were called for, my lord. And 7680.
498, 406,
323.
and the case has been there because of the fact that a CP
No,
case.
306.
No, nothing.
no.
Nothing
All,
serious.
granted it. Why are both the matter granted.
Surrender and religion.
But you have to cooperate. Huh?
Yes, my lord.
Charge sheet has already been filed.
My lord. Surrender and religion will be for the court below, man. Because charge sheet has been submitted. Surrender.
I will grant anticipatory bail.
In the immediate RC melody, charge sheet has already been submitted.
Charge sheet submitted. That's why surrender religion bail.
The petitioner has the common order shall I pass? Both common order or separate? Separate order. The petitioner's
First case is husband.
Petitioner is an accused on so FIR. He is the
husband of the informant.
The husband of the
informant.
Husband of the informant. At the stage of investigation, the present application for anticipatory bail has been moved. Meanwhile, the charge sheet has already been filed. Therefore, Mr. Chan, in counsel for the petitioner, submits that his client's would appear before the court on or before 30th of September, so and so, and avail remedy as per law, with this liberty, the petition is disposed of. The petitioner is directed to appear or be surrender before the court below on or before 30th of September, so and so, and move appropriate application for grant of bail. If such application is moved, the same shall be allowed, owing to the nature of allegation and the nature of allegation, and the fact that the dispute is arising out of matrimonial discord, matrimonial dispute. The subject of the petition is discord.
I would second. I would another.
Both the petitions are allowed.
One is married said the husband, another married may say the in-laws. Only that will be the difference.
In-law.
Oh.
The case is arising out of a matrimonial dispute. The allegations are general in nature.
Hon'Ble.
29.
With condition condition to trial court will be. Yes.
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 29 not, I have to get some copy by Friday or Monday.
Urgent. I will not say anything. Urgent. Simply urgent. And urgent means see, I'm thinking of doing one thing. I was just discussing in the month of April, May, June, 3 months bail applications are there. 2 days I'll fix for all application for April, and another 2 days for May, another 2 days for June. So all the matter.
That is so again the same problem will arise.
Problems will be arise only.
Subject matter application. Who am I? My proposal matter April, May, June matter. Around 600 or 500 matters are there like that one.
I don't know. I am asking for a data.
Our rough calculation will be around 600. So as Malad is taking up the 50 cases per day. If that is so also, I think within a period of 8-10 days or 15 days.
So nobody should mention, so that we will take care of.
I will not mention.
We will work it out.
So head matter 25 ରୁ 30 ଟା matter ଆଜ୍ଞା ଅଛି 8 ଜଣ ଅଛି ବାକି 70 ଟା 75 ଟା dispose 25 30 ଟା matter ଅଛି 8 ଜଣ
ମାନେ maximum 600 700 case.
So serially
And there are a lot of tag matters.
serially 50 ଟା ଲେଖା ଆଣିଲେ ବି 10 12 ଦିନରେ
15 ଦିନ ବି ହେଲା 2 weeks ହେଇଯିବ.
Yes. Next. 29 urgent.
30.
Yes.
And he learned of that day. He in jail, and the only sister is lying home, and a mother. My lord may pass order to defer in the court of
Today they have said, my lord, tomorrow.
So what are the offences?
420.
What? 29 November 23. 29 November 23 custody. Yes. What is the amount?
12,91,000. Same to the
12,91,000.
Yes, ma'am. They agreed to pay. Agreed to pay in the last 2 pages. Yes.
What do you want? I told you that come with some money.
Tomorrow.
No, I can't keep on wasting time, waiting for the accused to. No, that order will be wrong. I don't want to make part of the order.
Yes, ma'am.
For while granting bail, I can't put onerous condition of. It's not a recovery proceeding. So he is happy to stay there in the jail. Let him stay for some time. put it after 15 days.
Yes.
No, we can't be under the grace of the accused. Keep on, see now, we are trying to find out way to release the matter. The matters are listed and the accused is jolly well wasting time for others. No, tomorrow is not possible. Put it for Monday. See, I can't put the system in place, you know, if this kind of things happen. That's the whole difficulty. Yes. Monday.
Tuesday, I'll pay more Tuesday.
Yes. Yes, next. 31. Yes.
My lord, item number 31, my lord.
Yes, sir.
My lord, I am today ill, my lord, I am ill today. I want 7 days time, my lord. This is last chance, my lord.
Six, an adjournment, urgent. October end.
32. My lord, here.
I am the sub-item, my lord, that is modern horizon. That is 2 items, my lord. I am for modern horizon, my lord.
The first item is
sorry,
745.
Okay.
Please allow Mr. Patil,
Yes.
please. The first item is 745.
Yes.
Here I am in custody. My lord, since 3/12/2023.
3/12/23. Okay.
My lord. The FIR was registered and the accused, principal accused.
What are the allegations?
Allegation 20B2C.
Recovery
from the other accused, not from me.
How much you tell me?
100 kg, 101 kg.
102 kg.
I was arrested 1 year after.
Because you are absconding.
That is.
Because you must.
No recovery and no other evidence.
If you abscond, then.
No, abscond. It was his house which was raided. It is not that my house or moving boss train.
But in fact, what happened was the police got information. They allowed us that these petitions are carrying ganja business. Thereafter, police went there, and the house was locked, my lord. And outside, they knocked the door. The police personnel, they opened the co-accused, my lord. Madan Harjan opened the door, and 102 kg ganja, my lord. His house, mother house, my lord. This petitioner, my lord, the first case, my lord, is the brother-in-law of the Madan Harjan, my lord. And he was absconded, and the case was split up.
Named the
FIR, my lord. Case was split up, and subsequently he was arrested on, my lord,
No, sir. What?
3/12/23.
3/12/23.
My lord.
What about the other accused?
Other accused, my lord.
Modern horizon, my lord.
From his house, my lord, he was present in the house. They recovered.
Okay. He is in custody since?
7/12/2022, my lord.
7/12/22.
Yes, my lord. And till today, my lord, trial has not commenced, my lord.
Ask for a report. In the first item, I am dismissing. Second item, you ask.
First item, my lord, there is no recovery, and the co-accused statement only.
Named in the FIR.
Named in
absconded.
My lord,
very fact that you are absconded, you are not entitled.
My lord, your lordship may see I have annexed the FIR. I don't say, my lord, how the things. I have also annexed the charge sheet also.
Recovery is 100.
Yes, my lord.
Less than 100, then I could have.
My lord, but
and not even 1 year.
The circumstance.
Not even 1 year custody.
But the circumstance, and moreover, in the meantime, this honorable court has granted 2 months bail to each of us to show the benefit. We have also surrendered. That it is.
Out of this December 2023, you went to custody. 2 months you remain outside.
That is, I should say the. Let both the matter comes together so that the antecedent and other aspect.
First matter revive after 6 months, and
Here,
second matter call for report.
Lordship then see page 10 of the FIR. How the things has what materials come out.
Whatever your conduct.
But what materials come out? I have annexed, my lord. I have annexed.
Where is the charge sheet?
Charge sheet, my lord, also annexed. Annexed to.
In the charge sheet, what has come against?
My charge sheet, my lord. If your lordship will have a glance over page 26, the last paragraph.
Yes.
Investigation of the case is complete. During course of investigation, prima facie evidence such and such. In this case, accused Madan Harijan. This is 20B2C29.
again against me also 29. At best, a case under section 29 against me. How is it that your lordship will find from page 10?
Anyway, I'm not inclined.
I'm simply drawing your lordship attention to page 10. What is the
right.
thereafter?
First item, I'm not in the PTs.
Then both the matters be taken apart together, my lord. It
But
was
I'll not
it
granting we.
may not, my lord. Granting or not,
October.
granting or not granting is your lordship's
October
decision.
end. October end.
Because on last two occasions, your lordship has said he is entitled to bail. So today is my unfortunate.
That day you should not have been.
No, they sought for time. They sought for time.
That's bad luck. What to do? Yes. Next 33.
ସରସ୍ୱତୀ ଆପଣଙ୍କ କଣ୍ଠରେ ଆଜି ବସିନାହାନ୍ତି ତେଣୁ ଆମର ଭାଗ୍ୟ ଖରାପ ଆଉ କଣ ମୋ କ୍ଲାଣ୍ଟ ବି ଯଦି ଦିଥର ଲାଷ୍ଟ ଶୁଣିଥିବ ସେ ଆଜି କହିବ ବୋଧେ ନ ଯାଇକିରି କଣ ହେଲା.
This is the beauty of this arguing bail petitions.
We are deriving pain out of that beauty.
Yes. Next 33. Last hearing also none appeared.
Perhaps, my lord, has been released on bail by the court below. I think, my lord, because the ganja in question, my lord, 10 kg. And the petitioner outside of Tamil Nadu.
Last hearing also nobody appeared. 10 kg he is entitled to bail. What to do? Shall I dismiss in default? It is not fair to dismiss in default in bail matters.
At this stage.
That is the reason I adjourn it. Pass it over, let us see. Otherwise, you should know whether he is already been granted bail by the trial court or what.
I have to take instruction that, my lord, since only adjourn thrice, my lord, twice, my lord, adjourn.
Because it was before the coordinate bench, none appeared. Thereafter, it came before this court, again, none appeared. Okay, let us see. Pass over it, you will see. Yes.
34.
Yes, 34.
May I pay that? I filed an IA for interim bail on the sickness of wife fellowship. Instruction was sought for.
Yes.
On the IA. My lords.
Mr. Ogadai,
Madam.
What kind of illness you have?
The wife of the petitioner is suffering from.
My lord. The instruction, my lord. I inquire regarding the treatment of wife of the petitioner at SLL her medical college and hospital, Koraput, and ascertained that Gita Guntha, wife of the petitioner, reported before the MO, SLL Medical College Hospital for gynecological complaints, who was suffering from irregular bleeding and a whiteness discharge.
This is
and a vulva pruritus and a burning urination. The medical certificate are genuine.
on the ground. What are the offenses?
Yes, yes, yes. Something has to come on this. You better. You need necessary. You need necessary. Made pressure. Made pressure. Pressure. The petition of of the NDPS Act, and the quantity of ganja involved is 1 quintal 53 kg 800 grams, and the accused in custody 23/6/2021, 3 years to
26
2021.
21. What is the stage?
It is in the stage of trial. Only one witness has been examined, Your Honor. Only one witness has been examined, and till now,
recovery is 1 quintal.
1 quintal 53 kg.
153 kg.
And he's in custody, Your Honor.
I'll 1 minute. I'll seek a report from the trial court. What is the process? So therefore, you can get the benefit of Ravi Prakash if the trial is not moving.
Already, your lordship, my lord, directed the trial court to. The order dated 23/80/24.
23/80/24.
Your lordship called for a report from the court.
Report is there.
Report is available with your lordship.
What is the report?
Frag deep.
What happened on 12th of September?
12th of September, my lord. No, the trial is further witness have to be examined. Only one witness has been examined, my lord. Only one witness, and trial has not further. There is no further progress in the trial. And my lord, I am in custody since 3 years, 2 months, and 10 days. It is causing
Yes.
great hardship.
Yes, Mr. Rahul, what do you say? 3 years custody, only one witness examined.
Yes, my
Is
lord.
it not entitled to the benefit of Ravi Prakash judgment?
Yes, my lord.
Have you seen Ravi Prakash judgment?
My lord, I have not come across you, my lord.
You check it up. I'll put it next week. Next week, you check it up. You may be getting benefit from that Ravi Prakash judgment. Okay.
My lord, you have gone through that case record, case law. Maybe please to consider.
Citation, I don't remember the citation. There are two judgments, Ravi Prakash and
My lord, since
do you
taking
have
into,
that judgment?
my lord, taking into consideration 3 years, 2 months, and 10 days.
Yes, that is the reason I'm saying.
My lord.
If the trial is not proceeding at the expected pace, then owing to the length of custody, you are entitled to the bail. You just check it up. We'll just check it up. Put it next week. Yes.
Ravi Prakash, my lord. Ravi Prakash versus State of Odisha.
Yes, Ravi.
2023 SEC online.
2023 ACC online.
Supreme Court 1109.
1109. Ravi Prakash versus State of Orissa. Check it up. Yes.
37.
37.
May I please, your lord?
Yes.
My lord, though the petitioner is in custody since 22nd November 2023, but remanded in the present case on 4/12/2023, your lordship, for offence under section 394 of IPC. The FIR was lodged against on
How
two
many cases you have?
My lord, I have 4 cases. In one case I have arrested in 399/402 of IPC. Thereafter, in another 3 cases, I have been remanded, my lord, which has been lodged against unknown persons prior to that.
What is
Same
the
nature of allegation.
same? What is the stage of investigation?
Investigation, my lord, of final.
My investigation has already been submitted.
Where is the charge sheet? You have not
23/01/2024.
Yes, charge sheet. Just see. What are the allegations? What are the allegations? Tell me. Yes.
Basing upon confession of co-accused, in the charge sheet it is stated that because in the allegation there are 2 culprits committed the offense, but charge sheet has been submitted including the present petition 3 accused persons. The informant alleged that 2 accused persons came with
Your
mass.
name is, what is your name? Your name is
Sujit Naik, my lord.
But this petitioner was, according to the confession of the another co-accused, that he was along with them.
No, except co-accused confession.
No.
What else you have?
There is nothing, my lord.
Have you read the charge sheet?
Yes, my lord.
You have a copy of charge sheet?
Yes, ma'am.
Show me which part. There is enough to do. You read and tell me. So you can't give me a bunch of paper. I'll keep on reading. You want to file either. I would have read it. Except FIR, there is nothing. You give me a bunch of paper. If I'll read, then it will take half an hour.
No, my lord, I have given the charge sheet, my lord.
But you have to tell me which part.
My lord,
Least it up.
if your lordship,
Least up one. Give
your lordship may call it tomorrow, my lord.
Not tomorrow. 1 week. You have to give effective assistance. Otherwise, it's very difficult. I can't handle so many.
The case in which he was arrested, he was released on
that, but in this case, what are the allegations against you? You have to at least show me this page or that page. You can't give a bunch of paper and
your lordship may
ask me
call
to
it
read.
day after tomorrow. I will
see 1 week. Yes, next.
38.
38. You must point out which are the relevant pages and lines, whatever. Yes.
Maybe.
Call it day after tomorrow, I will appraise your words.
See, we want to place a system in place. Not that in one matter I can keep on hearing.
Why I am submitting, my lord, the case in which he was.
I understood that much. You give that much credit that I understand what you say. Before you order, I understand what you say. In one matter you were arrested and 3 matter you have been taken in remand.
No, my lord. I have not been remanded in other cases.
After I grant bail, you will be taken in remand in the other 2 cases.
For that reason, you lost. Directed.
So therefore, better you should be there. Yes, next. 38.
May I please, your lordship?
Yes, sir.
The alleged offense under section 302/34 of IPC. Custody since 15/9/2023, my lord.
59/23.
23,
My lord, I may be pardoned, my lord. 2 letters has been sent from the state office, my lord. But CD could not. Yes, my lord. CD could not reach.
Last time also, my lord, CD is not available. Your lordship was direct.
Let me say, my lord, I am praying before your lordship. For the last chance, my lord, your lordship may allow to me, and I will obtain the CD at any cost.
The 302 case, let the CD come. Huh?
The case is
since my lord sent.
Okay.
February
I have last
19.
opportunity. The state council is granted time for 1 week to produce the CD, to obtain the CD. To obtain the CD, release the matter on 1 week after. Yes.
You lordship fix a date, otherwise.
Yes.
Thank you, your lordship.
Yes, sir.
My lord, offense under section 302/34 IPC, my lord. And the petitioner is in custody since 27/12.
Sorry?
27/12/2023, my lord.
23.
My lord.
Okay.
But the case of the prosecution is that the date of occurrence is 7/12/2023, my lord.
CD has come.
Yes, my lord.
Has the CD come?
My lord, there is no eyewitness to the occurrence, my lord.
Yes.
Only
My lord.
circumstantial evidence, my lord. Last occasion, my lord was pleased to call for the visceral report, my lord.
Yes.
My lord, may I read one of the last scene occurrence, my lord? ମୋ ନାମ ସୋ ଗତ 7/12/23 ଗୁରୁବାର ଦିନ ସନ୍ଧ୍ୟା ସମୟରେ ପିଙ୍ଗୁଆ ବଜାରକୁ ଗ୍ଲାସ ସିଲିଣ୍ଡର ଆଣିବାକୁ ଯାଇଥିଲି। ସମୟ ପାଖାପାଖି 6ଟା ହେବ। ମୁଁ ପିଙ୍ଗୁଆ ମାର୍କେଟରୁ ଘର ଦେଖିବ ଅର୍ଜୁନ କେତେ କରୁଛି ଏଟା ରଖିବ।
This case, 376 and allied offenses, your lordship. Major lady. Now the matter has been settled, your lordship. The victim is appearing.
Custody since?
Custody since, my lord. 24/12/2023.
24/4/2023.
24/12/2023.
Yes. Who is that lady? 30 years, huh?
20.
What is the settlement?
It was out of the family dispute, your lordship. Your lordship, 164 statement.
My lord, 164 is available, and also there is the medical report is supporting to the prosecution, my lord.
Right, but the major lady, she is filing an affidavit. What? Right. Petitioner is accused in so and so case. Allegation against the petitioner. After investigation, charge sheet has already been filed in the present case. The petitioner is in custody since 24/12/2023. The informant, she is the informant? The informant, who is the victim in the present case, was noticed by this court. She is appearing before this court in person and also represented by an advocate. She has filed an affidavit before this court, affidavit dated 30th September 2024. No, 3rd September 2024. 2024, inter alia, stating that.
My lord, may I pardon, my lord? Yes. May I take the instruction regarding the affidavit?
Affidavit she is giving, and he is going to identify. She is appearing here. Inter alia, stating that he has settled the dispute with the accused petitions. The informant victim is present in the court and identified by her counsel. and she has also filed self-attested copy of Aadhaar card, which is placed on record to establish her identity. The affidavit and the Aadhaar card, photocopy of Aadhaar card is taken on record. From the query, on the query from the court, the informant opposite party submits that she has no objection if the petitioner can last on bail. Regarding the bail, petitioner is entitled to bail. Granted. Yes, next. Yes.
41.
May I please, Your Lordship?
Yes, please.
Your Lordship, both the petitioners are in custody since 22/1.
My lord, I'm sorry to say, my lord, this is same also, and within 1 week I will obtain the CD, my lord.
CD.
Yes, my lord.
CD. CD. Yes, next. Huh? 42.
May I please, Your Lordship?
Yes, madam.
Your Lordship, the petitioner is in custody since 4/1/2024.
4/1?
2024. Charged under section 498A and 302.
302.
Yes, Your Lordship.
Your husband?
Husband, Your Lordship.
What are the allegations?
That the husband has poisoned her and she has succumbed to death.
You have administered
My-
poison. Medical report, yes. Medical report.
My lord, my medical report, postmortem report reserved, and regarding the test of viscera, my lord, and that report also I have been obtained, my lord.
Viscera.
Yes, my lord.
Yes.
Definitely, my lord, that is the poisonous compound was detected. But my lord, your lordship may allow to me to read the 161 statement of the mother of the accused. my lord.
Read it.
The more
Relevant
than-
part.
Yes, my lord, relevant part. ଗତ 5 ବର୍ଷ ତଳେ ଅର୍ଥାତ୍ 23/6/19 ରାଉତପଡ଼ା ମଠରେ ଥିବା ଦିବାକର ତ୍ରିପାଠୀଙ୍କର ଝିଅ ଶୁଭସ୍ମିତା ତ୍ରିପାଠୀଙ୍କ ସହ ବାମଡ଼ା ସ୍ଥିତ ଲକ୍ଷ୍ମୀନାରାୟଣ ମଣ୍ଡପରେ ମୋର ପୁଅର ମାନସ ରଞ୍ଜନ ପଣ୍ଡାଙ୍କ ସହିତ ହିନ୍ଦୁ ରୀତି ଅନୁସାରେ ବିବାହ ହୋଇଥିଲା। ବିବାହକୁ ତାର ବାପା ଦିବାକର ସେଠି ଆସିନଥିଲେ। ଉକ୍ତ ବିବାହରେ ସ୍ଥାନୀୟ ବ୍ରାହ୍ମଣ ସମାଜ ସହାୟତାରେ ଝିଅର ମା ଭାଗ୍ୟବତୀ ତ୍ରିପାଠୀ ଓ ସ୍ୱାମୀ ଦିବାକର ତ୍ରିପାଠୀଙ୍କ ଉପସ୍ଥିତିରେ ବିବାହର ହୋଇଥିଲା। ପରେ ପୁଅର ଔରସରୁ ବୋହୂ ଗୋଟିଏ ପୁଅ ଜନ୍ମ କରିଥିଲା, ଯାହାର ନାମ ସାଇ ପଣ୍ଡା 4 ବର୍ଷ ହେବ। ମୋର ପୁଅ ବାଲେଶ୍ୱର ଇଲେକ୍ଟ୍ରିକ ଶୋରୁମରେ ସେଲ୍ସମ୍ୟାନ ଭାବେ କାର୍ଯ୍ୟ କରୁଥିଲା। ସ୍ୱାମୀ ସ୍ତ୍ରୀ ମଧ୍ୟରେ ଅନେକ ସମୟରେ ପାଟିତୁଣ୍ଡ ଲାଗୁଥିଲେ। ଏପରିକି ମାନସ ତା ସ୍ତ୍ରୀକୁ ଗାଳିଗୁଲଜ କରିବା ସହିତ ପିଟାମରା କରୁଥିଲା। ପୁଅକୁ ଯେତେ ବୁଝାଇଲେ ମଧ୍ୟ ମୋର କଥା ସେ ଶୁଣୁନଥିଲା। ଏହାକୁ କେନ୍ଦ୍ର କରି ବୋହୂ ମରିବାର 8-10 ଦିନ ଆଗରୁ ତାର ବାପା ଘର କେନ୍ଦ୍ରାପଡ଼ାକୁ ପଳାଇ ଯାଇଥିଲା। ବୋହୂର ବାପ ଘରର ଲୋକମାନେ ବୁଝାବୁଝି କରି ଆଣି ଆମ ଘରେ ଛାଡ଼ି ଦେଇ ଯାଇଥିଲେ। ବୋହୂ ପୁଅ କାମ କରୁଥିବା ଦୋକାନର ମାଲିକକୁ ତାର ଦରମା ପଇସା ପୁଅକୁ ନ ଦେଇ ତାର ଆକାଉଣ୍ଟକୁ ପଠାଇବାର ମୁଁ ଶୁଣିଛି। ଗତ 22/11/23 ରାତିରେ ପୁଅ ବାଲେଶ୍ୱରରୁ କାମ ସାରି ଆସି ପୁଅ ବୋହୂ ସାଙ୍ଗରେ ପାଟିତୁଣ୍ଡ କରୁଥିଲେ। ସେଇ ରାତିରେ ପୁଅ ବୋହୂ ଖାଇସାରି ଗୋଟିଏ ଘର ରୁମରେ ଶୋଇଥିଲେ। ତା ପରଦିନ ସକାଳେ ଦେଖିଲା ବେଳକୁ ବୋହୂ ମରିଯାଇଛି। ମୃତ୍ୟୁ କାରଣ ଜଣାପଡ଼ି ନାହିଁ।
Mother of the accused. Mother of
Mother
the
of accused.
Your Lordship, it is entirely based upon the assumptions. Your Lordship, other relatives of the
Hey, you just show me any evidence where he has administered the poison.
Poison dictated.
Poison was dictated, that's right. Whether she has taken herself or it is being administered by you. Show me any evidence. Get ready on that.
No. Regarding that part, my lord, I have to verify.
Get ready on that.
My lord.
1 week of, yes.
published.
Because you have implicated him for 302. Unless you make out that case, how 302 is made out?
30
It may be 306.
6, my lord.
Then
It is
if
clearly,
306, she
clearly
is
it is,
entitled to pay.
my lord, poison is dictated.
Poison may be. She might have consumed the poison herself.
2 may not be.
So then, you tell me 1 week up to Tuesday. Yes. 43.
May I plead your lordship? The petitioner being the husband in custody since 23/12/2023, your lordship.
23/12.
2023.
Yes.
In the meantime, charge sheet has been submitted under section 498, 302 of IPC, Your Lordship.
302, again,
Yes.
same story. You tell me. How?
Your Lordship, no eyewitness is there. Only on suspicion the FIR was registered, Your Lordship.
Poison.
No, poison.
Thank you.
Assault. Assault by a stick. Only on suspicion.
Yes.
My lord, the postmortem report is supporting to the prosecution, my lord. And the confessional statement has already leading to the discovery of the wooden thenga, my lord. And
They were there in the house, two of them.
No, both of
at the jungle, my lord.
let me see. Both of them went to the cultivation field, Your Lordship. There is nearby jungle is there. Both of them went. That is the prosecution story, Your Lordship. As because the mother didn't return, the son registered the FIR. I suspect my mother has been killed by my father. All the statements are consistent. ଆମେ ସନ୍ଦେହ କରୁଛୁ, ଆମ ଅନୁମାନ ହେଉଛି.
In the house who were there, you and your wife.
Because the case is that, Your Lordship, the couple had 3 children, Your Lordship. Elder daughter eloped with somebody else 1 month back, Your Lordship, for which there was continuously there
What
was
are the
arrest.
evidence?
My lord, though the matter has been happened in the land, my lord, cultivated land at the jungle area, my lord, both the wife and husband had gone to the field, my lord. And earlier, one incident has been happened with one of your mother, middle daughter. That daughter has been loved someone and fled away from her house, my lord. So regarding that matter, they both have called each other. And then they enter into the jungle for collecting the woods, my lord. And meantime, the husband remaining in backside and collected a wooden finger, my lord.
Plank and
yes, my lord, and attacked to
the head,
my lord. And the prosecution report is all the external injuries and internal effects are antemortem in
It's
nature.
all right. The story is all right, but what are the evidence to connect him? He has done it.
My lord, leading to discover the weapon, my lord, by the accused Chandra, my lord. That
is
27 to what extent you press 27? Anything else? Last scene, anything?
No.
Huh? No other evidence. No other evidence except 27 recovery.
Yes, ma'am. Confessional statement.
Confessional
and
statement to
leading
what
to
extent?
discover
And any evidence of any daughter, son, anyone?
No, my lord.
Not recorded. Then what have you done? Nothing. Nothing. In a murder case, you.
My lord, keep it next week and I will.
In a murder case, except relying upon 27, nothing is there. Confessional statement. You want to convict him on the strength of confessional statement, his own confessional statement. No evidence, nothing.
Let me.
See, he's in custody since 23/12/2023. If you don't have anything, then I'll grant bail.
My lord, the one statement of his son, my lord.
What does he say?
I said that the 10:30 ସମୟରେ ମୋର ବାପା ଆନନ୍ଦ ସାହୁ ଓ ମା ବୈଜୟନ୍ତୀ ସାହୁ ମିଶି ଆମ ଘର ପାଖରୁ 2.5 କିଲୋମିଟର ଦୂର ଗଣ୍ଡରମୁଣ୍ଡାରେ ଥିବା ଜମିକୁ ଧାନ ଗଦା କରିବାକୁ ଯାଇଥିଲେ। ସନ୍ଧ୍ୟା 5ଟା ପର୍ଯ୍ୟନ୍ତ ସେମାନେ ନ ଫେରିବାରୁ ମୁଁ ଓ ଆମର ସମ୍ପର୍କୀୟମାନେ ଖୋଜିବାକୁ ଗଲୁ। ଖୋଜିବା ସମୟରେ ଗଣ୍ଡରମୁଣ୍ଡା ଜଙ୍ଗଲ ମଧ୍ୟରେ ମୋ ମାର ମୃତ ଅବସ୍ଥାରେ ପଡ଼ିଥିବାର ଦେଖିଲୁ। ତାଙ୍କ ମୁଣ୍ଡରୁ ପ୍ରବଳ ରକ୍ତସ୍ରାବ ହେଉଥିଲା। ବାପାଙ୍କୁ ଖୋଜିବାରେ ଆମେ ପାଇଲୁ ନାହିଁ। ପରେ ମାକୁ ଆତ୍ମଲିକି ଡାକ୍ତରଖାନା ନେଇଯିବାରେ ଡାକ୍ତର ମଧ୍ୟ ତାଙ୍କୁ ମୃତ
Anybody has said that the father has, the accused has gone with the deceased? Last scene? Anybody has seen?
I mean, pardon,
Then
I have to verify one sentence.
How will you connect him? Oh, again, 1 week further. You read that and tell me. Because this is a murder case. If you don't have any evidence, I have to grant bail, irrespective of whatever. 1 week further.
Next week,
Yes. 44. Yes.
Your Lordship, item 44 is also a CBI matter. I'm praying for a short adjournment on behalf of the.
But 3 times, my lord, every time he's custody since last 5 years, my lord. More than 5 years.
In fact, there is a personal problem. There is. Because his father is suffering from heart attack.
Yes, that I know, my lord. Short adjournment, my lord, because.
Short adjournment. Your Lordship. Your Lordship, one more request. According to the order of the Honorable Supreme Court, CBI cannot be represented by Republic of India, Your Lordship. So the cause title has to be amended here, Your Lordship. CBI has to be implemented as a party directly, Your Lordship, as Central Bureau of
To
Investigation.
change it, this is the old fashion of writing, Republic of India.
That I'll do.
You change it.
That I'll.
Give it now, you will change it. Huh? Only the first line. Oh, the paper, you have to file paperless. You have to file 100 new party.
Okay, ma'am.
Mr. Paul, like the council for the petitioner, submits, I think you would be demanding the cost items. Oh, it's permitted to do so. At least in a proper. Yes.
45. Much of.
May I please, madam? Initially, FR lodged under section 294, 509, 12 of
Section 376 2N, 500, 506 of the Indian Penal Code, read with section 67 of the IT Act. I'm in custody since 1st December 2023. Charge sheet has also been submitted. Well, here the victim is 27 years old and the petitioner is 52 years. Well, on the last occasion, while I was submitting the case, I draw the attention of the Honorable Court to the fact that this victim is in habit of lodging false information.
That I have recorded last.
That was recorded, my lord. I had given the judgment of one case, my lord, where, my lord, may kindly see the judgment. If the present case will be accepted, then by that time she was in relationship with the other accused who has been acquitted because he has not hosted. My lord, may see. The statement is PW1.
Yes, madam. My submission is fine.
And peculiarity of the case is the same in Virendra Senapati, my lord, who has been examined as PW3 investigating officer. Here also, he is Virendra Senapati is the person who is investigating the case. Virendra Senapati is the same police. My lord,
It is executed. This is executed.
my lord.
How many cases he has filed against?
My lord, and around 3-4 cases, my lord, I have to that last order was passed. The local lawyer says 3-4 cases have been filed against some others, but before 376, and after taking some money.
Okay.
My lord, there is no legal bar that the IO.
Legal bar doesn't mean that you keep on.
No, my lord.
That 376.
No, my lord. No, that is legal. There is no legal bar that the same IO cannot investigate the matter of the same.
Saying that he has investigated.
And my lord, another thing is
in one police station you keep on filing 376.
No, my lord.
And that too, there also, my lord, in the other case which has been ended in acquittal, there also 161 statement is there, where she has categorical stated, when I was a student of class 3.
How many cases total you tell me?
My lord, there is no only one in the case record, my lord, that what my lord senior has given that judgment copy that. Only that allegation is there.
That judgment is of the
And
last.
there is no any other.
There is no other.
There is no any other cases was pending. What my lord, if my lord senior give me that number. And my lord, another thing is, well, your lordship will decide the bail matter. It is not the past conduct of the informant is not
That's
relevant.
right, but
And the material
also bearing in the.
And my lord, there is sufficient materials against the present petition in this case, my lord, because 66A is there, 67 IT Act is there. And
ସେ କେସରେ ଆର୍ଟିକଲ ହେଇଗଲା ପରେ
that
164 read.
my lord, new photos was seen.
So prisoner's petition.
Yes.
49.
Lakshman, look at the last order, your lordships.
Yes.
This is a, let the documents, photographs speak for themselves. I think my best argument will be the photographs here.
My lord, before my lord and senior argument, my lord, kindly see the order dated 8/8/24, my lord.
That's what I am reading. Case will be taken up.
Only after seeing these photographs.
And if the informed victim has an infection, she shall appear in person in the court and to mode stated, leave the informed victim agrees to appear through the mode, the concerning doctor in charge. Yes.
And also, now, after seeing the photographs, this honorable court was persuaded to pass the other order. And now the charge sheet has already been filed. And I'll just read out 3-4 lines.
They are married.
My lord,
They married.
yes, actually, my lord, the photographs tell the story by themselves.
Yes. What is this? What is the stage then?
No, charge sheet has been filed. He's already behind the bars for 6 months, more than 6 months.
Custody form?
Charge sheet has been filed.
Hey,
on
custody.
Custody from by 22 to 2024. 2024. Charge sheet filing. I'll just read two
Yes.
sentences during the charge sheet.
Hmm.
During further course of investigation, it is ascertained that both the victim Supriya Suchandan and accused Sangram Das, most of the time, they had kept close contact with each other, visited the place which which are mentioned by the victim during the course of recording of the statement under 161. That is the lodge at Konarak area.
You are 28. What's the age of the girl?
Girl is the major. 18.
My lord, that order,
18 years.
my lord, lordship gone through that order, 8824.
Yes.
It
You are supposed to appear.
It was directed that to appear the informer, pro VC. And matter was posted to 22 August 24.
What happened? Why she is not appearing?
That was not listed.
I don't know.
There is an order. Not appearing.
There's only after seeing these photographs.
That's right, but if there is an order that has to be complied,
No,
what to do?
Tomorrow?
No.
They can appear to the ILC tomorrow virtually.
I'll pass it over and do it today.
I'll
pass it over. Do it today. If she comes, then we'll.
My lord, not possible today, my lord.
Because
Because
you
you will
go to the house of the victim and they.
And the victim will come to the police station and appear, my lord. A date may be fixed, my lord. In that date, I will intimate the IAC to bring that victim to the police station.
The date was there. Why he should?
No, it was not listed for us, my lord. On 8/8, no date was fixed to 22nd.
Okay, tomorrow then. Tomorrow. Tell. Because they are married unnecessarily. Their life is spoiled unnecessarily.
With pressure of the father, she went and recorded a 164.
Maybe. Letter appear.
My lord.
Tomorrow, huh?
My
You just inform. Because there is an order of the coordinate bench.
My lord.
Therefore, yes.
Grateful.
Next.
50.
May I please, my lord? Here the accused petitioner is in custody since 22 January 24. The accused
22? 22?
January 24.
Okay.
The accused husband is a teacher. Initially, on the basis of the report lodged by the mother-in-law, the accused husband was implicated in a case on section 304B of IPC.
Yes.
Initially, as per the FIR, there are 4 accused persons. During investigation, the investigation officer could not find any clue. The involvement of other accused persons. So, final form was submitted against 3 accused persons: the mother-in-law, sister-in-law, and nephew. And
You are the husband.
He is the husband.
Okay.
Only charge sheet has been submitted against the husband only. My submission is the death of the
My lord, charge sheet, my lord, on 18/3/24.
18?
18/3/24. Rejection order is 19/3, just one day after my.
Petitioner is?
Petitioner is the husband, my lord.
Yes.
Within 6
What
months
are the
of marriage, my lord, she was died. And the PM report is that
306.
my lord, 498, 304B, 306 is not right. 304B, 323 and 4 DP Act, my lord.
40.
And the reason is, my lord, that is matrimonial dispute. And PM report is that applicable hanging.
Within how many days of marriage?
My lord, marriage was on 11/7/23.
11/7?
She was died on 19/1/24.
Died of hanging.
Hanging.
My lord, that is applicable hanging. Yes.
Hanging.
My lord. And the present petitioner was not present at the time of.
Then I grant the bail, but he was not the present one. I know. Petitioner is accused. So. Yes, allegation against the petitioner. After investigation, although the FIR was registered against petitioner and other in-laws, but the charge sheet has been filed only against the petitioner. Petitioner is in custody since 22/1/2024. Charge sheet has been filed for the alleged offence under section so. Which goes but the state submits that. What did you say?
My lord.
You said something.
No, no.
No, you said earlier. I forgot it.
Well, I said that PM report is applicable hanging and the reason is that matrimonial dispute. One of the witnesses that neighbor, my lord, he
Hmm.
has stated, my lord, only relevant portion I am reading. That
with
Sudham Sethi, present petitioner, my
They are
Sudham
staying
Sethi
to
ମତେ
happily.
କହୁଥିଲା ଯେ ତାର ସ୍ତ୍ରୀ ତା ଠାରୁ ଡିଭୋର୍ସ ନେବାକୁ ଚାହୁଁଛି କାରଣ ତା ସ୍ତ୍ରୀକୁ ସେ ସାଂସାରିକ ସୁଖ ଦେଇପାରୁନି। ତାର ସ୍ତ୍ରୀ ତାକୁ 5 ଲକ୍ଷ ଟଙ୍କା ଭରଣ ପୋଷଣ ଦେଇ ଛାଡିବାକୁ ଚାହୁଁଛି। ମୁଁ ଏ ବିଷୟ ନେଇ
he was not there, you said.
He was not there, man.
He was not there.
Admitted he was in the school at the time of occurrence. He was there.
That's what I hear. Yes. Already. So with that, although this is a case of hanging, death by hanging, hanging. And although the deceased has died due to hanging, and the marriage between the accused and the deceased had taken place on 11/7/2023. But at the time of the alleged incident, the petitioner was not present at the spot, rather he was in the school being the teacher, being the teacher. The petitioner is in custody since 22/1/2024. Regarding to the fact that the petitioner is in custody for about more than 9 months, about 9 months, and the charge sheet has already been filed. The dispute is arising out of a matrimonial discord. I'm inclined to enlarge the petitioner on bail, granted bail. Yes.
Privilege.
Yes.
I have 3 to 4 members. Interim bail is there.
Interim bail ground?
Ground bail or illness.
Illness of whose
Of the
illness?
person who is.
What kind of illness?
Illness, different types. She is a lady and without having any antecedent.
No, what kind of illness?
Illness is the appendix and other things. And they have gone to the jail. Jail authorities also advise them to file petition so that they can.
No, see, there are many applications on the illness ground. I'm listing all of them serially.
But she is a lady of age.
That's right, but
I
then
have filed-
about 30-40 applications have come by now. And wherever I find that the interim bail application are frivolous, I am rejecting the main bail plea also, along with the application. That risk is always there.
Let it be, let me take the.
Because many applications are filed like that,
Let me take the.
interim application.
No, my lord.
And the report comes that the illness is.
My lord, my report will be authentic. That I am sure.
You are so sure that you could manage them.
No, not. I have filed the memo.
I'll see that it can be taken.
My lord,
Yes.
with my lord's permission, may I mention weekly list item 134, my lord. Will my lord take today at anytime subject to my lord's convenience?
I understand. Let me see. If
At the end
I can
of the
finish it
board-
up for the miscellaneous matter, then I can definitely take it.
Yes, at the end of the vote, only 5 minutes, my lord. I want to
Yes, wait till 3:30.
I will-
We'll see.
deeply listen.
Where is that order?
Page 7 on this here.
Running page, my lord, page 7.
You didn't appear, huh?
Yes, ma'am.
Right. Due to
The activity
the
was
petition.
direct.
Petition is agreed by the order dated 8/2/2024 passed by the additional sessions judge and Gould in CT bracket S case number 2 of 2021, whereby non-bailable one has been issued against the petitioner because of his absent default in appearance. On instruction, Mr. Chand, the counsel for the petitioner, on instruction, the petitioner, his client would appear before the court on or before 25th of September so and so, and avail remedy under law. Till then, the execution of the NBW order issued by the court below by the order dated 8/2/2024 shall be kept in abeyance. The present order is subject to the petitioner depositing 1,000 as a cost before the High Court was. Yes.
ବଡ ଓକିଲ ସାର୍
Satisfied.
ବଡ ଓକିଲ ସାର୍ 2000 ରୁ 5000 ହବ କାରଣ ତାଙ୍କ କ୍ଲାଏଣ୍ଟ ଫଲ୍ସ ମେଡିକାଲ ସାର୍ଟିଫିକେଟ ଦେଇତାର କହିଲେ ଗୋଟେ ହସ୍ପିଟାଲ
1500 କରନ୍ତୁ opposition 1500 2000 okay 2000 ବାର ତ ଦେବେ ଆଉ କଣ
ବଢା ଦେବେ
2000 yes satisfied କରିଦେବେ eventually satisfied କରିଦେବେ yes yes
Well, my lord, petitioner is the informant.
NBW, I'm satisfied. What is the court? Yes, I'm satisfied. Yes,
Petitioner is the informant. And offense is 3762N 450 and 506.
Oh, closure report filed.
No, my lord. My lord, she has filed this, though she was married in another place and blessed with a child. So she has filed for quashing the affair.
She is the informant herself.
She is the informant.
Where is the accused?
My lord?
Accused? 376.
Accused has 376. Accused has not come forward. Informant has come that though she was married and have blessed with a child, marriage in another place to another person. So she has filed this for question.
What to do?
My lord?
What to do?
Let it be urgent, my lord. Let the petitioner counsel appear.
Notice was issued to opposite party.
14/5/24, it was urgent.
No, it is only urgent. Notice has to be issued to the accused.
Right.
Issue notice to non-appears for the petitioner. Petitioner, the petitioner is the informant in the present case. She has filed the present petition seeking quashing of the entire criminal prosecution initiated by her against the petitioner, against the opposite party number 2, on the ground that she has already married elsewhere and settled in her life, and she doesn't want to proceed against the opposite party number 2. Issue notice to opposite party number 2, returnable also. Yes. 13. Yes.
Subsequently, after completion of the investigation, committed against the petitioner, that is mistake of time.
You are seeking quashing?
No, my lord. Finally, report was submitted in the year 2022. London court has issued notice to the informant that if you have any objection, you file an objection before accepting that final report. He has challenged that notice.
Let it be. Maybe. No, not unnecessary. She has a right to file protection. You have a right to defend yourself.
You may have filed protest petition.
Whatever.
What expedition?
You don't know whether she will file the protest petition or not. She may not file. She may keep quiet. Why are you inviting all this problem? You are inviting problem for yourself. notice is issued, she may not come also.
And if
Keep
she will
quiet.
not, if she will not file, it will be
Why
accepted.
are you aggravating things? I don't know. Whatever, nothing is happening, keep quiet. You are filing this case, inviting problem for yourself. The complainant may not be interested to prosecute you. If I issue notice, she will come and start, prosecuting you. So please withdraw it. It is better for you. Please withdraw. Don't do that. Then counsel for the petitioner seeks to withdraw this petition. You have determined to send your client to jail. That is what you have decided. A closure report is filed. Trial court has issued summons to the complainant. Complaint is not coming forward. You are coming to the court. Please give a direction. Why are you doing this? No, withdraw. Yes. Next.
33.
Yes, 33.
10 kg of ganja, my lord. But last 2 times, my lord. Today,
10 kilo.
Third time, my lord. The petitions counsel not appearing, my lord. And
What to do? Whether
since my lord, the only 3 witnesses there, my lord. PR submitted and 3 witnesses. The trial must have been completed. The lordship may dispose of with liberty if he survive.
None appears for the petitioner. Earlier, when the matter was taken up on 8/2/2024 and 23/8/2024, none appeared for the petitioner to press the bail application. Even today, nobody is appearing for the petitioner. Petitioner. Mr. Agadar and counsel for the state submits that the trial is proceeding at an expected pace. And that perhaps the reason the petitioner.
Only 3 witnesses are there.
Petitioner and only 3 witnesses remain to be examined.
That is total 3 witnesses, my lord.
There are only 3 witnesses in the present case. That perhaps the reason the petitioner is not interested to press this petition. Be that as it may, the present petition is disposed of with liberty to the petitioner to file renew the bail plea before the trial court. With this observation, disposed.
47.
47. Yes.
And if the case survives, there, my lord.
Obviously, otherwise why should he file? Yes.
The petition lordship, allegations 372 lordship.
Yes.
Petitioner is since bar 2023.
Bar
2023.
23.
It happened out of office settlement post lordship.
Yes.
My lord, 20B 2IC and 25, 29 NDPS.
Recovery?
Recovery 125 kg from the car.
None appear for the petitioner in the interest of justice urgent October. Yes.
Both the matters, my
Both the matters. Okay. 24/11/23. 164. Read it. Not come. CD is there.
No, CD, that is there.
Huh?
Only CD is not available.
That's right, but CD has to see what are the reasons. Right, call for CD, least after 1 week. Yes. Now date. Yes.
53.
Matter relates to the section 76, but the
6/1. 24. Okay. 164 justice. Read the 160. What is the age of this boy?
19.
Boy is 19. Girl is 19. He is 23. Yes. 164.
Rejection on 13/2. Charge sheet on 23rd February.
13.
Charge sheet on 23.
Charge sheet.
Charge sheet 23 February 2024.
24. 24.
Yes. Rejection is on 30th February 2024.
Just see 164.
Yes,
If something, nothing serious, then I will. Yes. 164 do you have?
Yes.
Read it. Relevant part.
ଗତ ବୁଧବାର ଦିନ ସମୟରେ ଘରେ ଧାନ ମପେଇକି ଫେରୁଥିଲି ଘରକୁ କୁଟା ଗାଁରୁ ମୋ ମାମୁଁ ଘରୁ ନଦୀ ପାର ହେଲା ପରେ ଅକ୍ଷୟ କୁମାର ସେଠାରେ ବସିଥିଲା। ମୋତେ ଦେଖି ସେ ମୋ ପାଖକୁ ଆସିଲେ ଓ ମୋତେ କହିଲେ ସାଇଡକୁ ଆସ। ମୁଁ ନାଇଁ ନାଇଁ ଯାଇପାରେ କହିଲି। ସେ ମୋତେ ଜୋର ଜବରଦସ୍ତି କଲେ। ମୁଁ ଗଲି, ତାପରେ ସେ ମୋ ସହ ସମ୍ପର୍କ ରଖିଲେ। ସେ ମୋତେ ଜୋର ଜବରଦସ୍ତି କରିଥିଲେ।
Compromise, nobody is there. Appearance, appearance, 12 appearance and date to day, date to day. Okay. Next date. Yes. Trial. Bail matter mein how can I target? Trial and if such bail application is moved, the same shall be considered within 15 days. Yes. 54.
Item 54 I may be permitted, my lords. Custody since 16/1/2022, my lords. 2 years, 16/1/2022.
376 lordship.
Notice issued.
My lords, charge sheet submitted 376.
Late filing of
notice could not be issued because you filed the requisite lately. Necessary, the petitioner, though notice was issued to opposite party number 2, the same could not be issued. Could not be notice could not be served on opposite party number 2 due to late filing of requisites. The petitioner shall take the necessary steps for serving opposite party number 2. Release the matter. Yes. Next. 55.
Requisites already filed, my lords. That may be accepted, my lords.
May be permitted or not? May be accepted. Late filing. Accept. 55 withdrawn. Yes. 56. 56 adjourned. Yes. 57.
55 lord.
May be permitted, Your Honor, item number 55.
Yes, yes. Withdrawn. Here. 57, no? No? Yes, 57.
56.
Yes.
57.
Custody.
Custody since 6/12/2023.
23. Yes.
There is an allegation of
You are 50 years old. Pokso.
14 years lords.
No. I only give bail to the people those who are very young. Both the accused and all. You are 50 years. Girl is 14 years. Girl has already been examined?
No.
No.
Yes, examined.
Examined.
She has stated my that there is the allegation.
Then
I have the deposition copy.
Then what do you want?
300 trial may be expedited.
Right. Petitioner is not pressing the present petition at this stage. However, how many witnesses are there to be examined? Do you have any idea?
Total 19. Out of 19, my lord, 12 witnesses have been examined.
Right. However, submits that out of 19 witnesses, 12 witnesses have already been examined. This court should give necessary direction for expeditious disposal of the trial. Regarding to the fact that the petitioner is in custody from 6/12/2023, the trial court is directed to do well to see that the trial is concluded as expeditiously as possible, preferably within a period of 6 months. Yes. Yes.
There is no allegation against the petitioner.
Custody?
I am in custody since 27/10/2023. The facts are like this. The petitioner's sons and the deceased, they are all working in Surat. They came back to the village. They are, one day the deceased called them to go to police station. They did not agree. So he assaulted them. So there was some enemy and While he was passing, there was some were assaulted him and he died. The entire allegation against the present petitioner is that period. The grandfather of the deceased had said, ଆଇଲା ପୁଣିଆ ଏକ ଚାକୁରେ ମଙ୍ଗଳାକୁ କଟା କରି ଖାଇଲା ସୁରେନ୍ଦ୍ର ଭୂୟାଁ ମଙ୍ଗଳାକୁ ମାର ମାରି ନଥିଲା ଆଜି ସୁରେନ୍ଦ୍ର ଭୂୟାଁ ସେ ନିଜ ପୁଅ ମାନଙ୍କୁ ମାର ବଳି କରୁଥିଲା ପୁଅ ରହିଲେ ଗ୍ରାଣ୍ଡ ସନ୍ସ This has been development. Even they are not there.
Lalkara.
He lost the entire statement. He was not there, but he has been made an accused for some other reason.
On his,
Lalkara, yes.
on his behest, that is the 161 statement of the same
What
thing.
is
My learned senior is
what is the overtake attributed to him?
164 statement of the grandfather of the deceased.
Eyewitness, how many wait?
He himself had no overtax.
Any overtake attributed to him?
no, that is only his instruction only. How it was not
Read out
Read out.
the eyewitness count. Have you prepared or not?
Yes.
Read it out.
Actually, that is my name Mukesh Swai.
He is eyewitness.
Eyewitness means he has said that at that moment I heard that some other person is there.
I am asking who all are the eyewitnesses. Read the evidence of one eyewitness. Shall I pass it over? Will you read it?
Yes. Pass it.
1 minute, sir. Let him read it. And once, the moment you read it, tell me so that he is waiting since morning.
Yes.
Yes. Please read it and read out the evidence of eyewitness. Let us see what is his role. He is only has given Lalkara, then he is entitled to.
That is grandfather statement was present.
59. Yes. Yes. 59.
Yeah, 376 to 376 AB.
Non-APS for the petitioner.
Post-
Last time also. Good. Right on. When the matter was taken up, you are there? Yes, it's still. Yes, sir. You are in custody, tell me. 7/11? 23, okay. What are the allegations? What are the allegations? Read 164, sir. Yes, sir.
My
Please, 164.
A very lengthy statement, 164.
No, relevant party.
Relevant part, and 164, it is found that says categorically made allegation that the accused petitioner repeatedly committed rape on or forcibly against her will and blackmailed her.
Yes.
One Trinath Bhuya.
Huh?
No, Trinath Bhuya statement. Trinath Bhuya. 27/10 ଆପଣଙ୍କ ଆଗରେ ଦେବାର ମୁଖ୍ୟ ବୟାନ ଏହିକି ଯେ ଆଜି 27/10 ସମୟ ସକାଳ 8ଟାରେ ମୋର ସାନ ପୁଅ ବୁଲୁ ଭୂୟାଁ ଘରେ ଥିଲି। ଏହି ସମୟରେ ମଝି ସାହି କାଠଶାଳ ନିକଟରେ ଗୋଟିଏ ଗାଡ଼ି ପଡ଼ିବାର ଶବ୍ଦ ଶୁଣି ମୁଁ ଘରୁ ବାହାରକୁ ଆସିଲି। ଦେଖିଲି କି ଆମ ଗାଁର ସୁରେନ୍ଦ୍ର ଭୂୟାଁ ପିଟିସନର ତାର ଦୁଇ ପୁଅ ପପୁନ ଭୂୟାଁ, ବାଇଧର ଭୂୟାଁ ଓ ଜୟସନ ଗୌଡ଼, ଚନ୍ଦନ ଗୌଡ଼ ଏହି 5 ଜଣ ମିଶିକରି ମୋର ନାତି ମଙ୍ଗଳା ଭୂୟାଁକୁ ଚାକୁ କାତିରେ ମାରୁଥାନ୍ତି। ମଙ୍ଗଳା ଭୂୟାଁ ନିଜକୁ ବଞ୍ଚାଇବାକୁ ଦୌଡୁଥିଲା। ମୁଁ କାକୁତି ମିନତି ହୋଇ କହିଲି ଆଉ ହାଣ ନା, କିନ୍ତୁ ସେମାନେ ମୋ କଥା ନ ଶୁଣି ପଳେଇବାକୁ କହିଲେ। ତାପରେ ମଙ୍ଗଳା ଦୌଡ଼ି ଯାଇ ତାର କକା ପ୍ରସନ୍ନ ଭୂୟାଁଙ୍କ ଦୁଆର ମୁହଁରେ ପଡ଼ିଗଲା। ତାପରେ ଏଇ 5 ଜଣ ମଙ୍ଗଳା ଭୂୟାଁ ମୁହଁକୁ କାତି ଚାକୁ ପଥରରେ ହାଣି ଭୁସି ଛେଚି ମାରିଦେଲେ। ଏହି ସମୟରେ ପାଟି ଶୁଣି ମଙ୍ଗଳା ଭୂୟାଁ ଓ ବାପ ତା ପରିବାର ଲୋକ ଘଟଣାସ୍ଥଳକୁ ଆସିବା ତାକୁ ଦେଖି
ୱିଟନେସ୍ ନେମ୍
ତ୍ରିନାଥ ଭୂୟାଁ and no, it
Trinath Bhuya. 164 statement do you have?
Not where 164.
The acid has already been filed.
He says something else.
Yes, the part of the acid.
164 asking.
I given you everything I have given. Just next page of asking the yellow I have marked. I am not believing something.
Very specifically in the 164 he says that Surendra Bhuya Mongala को माड़ मारी नथिला किंतु से निज पुओ को पुओ मानकु मंगला को मारो बोली बारंबार कहूतला. Very specific.
But what happened in this case, Malad? Perhaps CD has not received, but in fact the documents supplied to by the council.
Get the CD next week.
And also 164.
164. And I want to copy that. Copy that. Give the copy.
No, 164.
164 is not there. See, if Tirnath Bhuya's statement is a... See, anyway, Tirnath Bhuya is the eyewitness. His 164 statement is recorded. He says something else. He says that very specifically, Mari Nothile. Mari Nothile. He is a Lalkara accused.
But the
Lalkar accused
will get. But a case date not received, my lord.
Case date
Basing on the
302.
Enter this
302 case date.
Antecedent.
Antecedent.
If there is any antecedent, I will.
Next. Yes. 1 week time I am granting Monday. Come what may you get it.
Specific in Monday.
Because 164 if you read is entirety. Yes.
I don't think that they can get any better document.
Yes.
6P.
Yes.
11th March 2024.
11 March.
Yes. Meantime submitted. Prosecution cases where the victim is a married lady of 31 years old. The present petitioner, while working in Bharat Finance, he is used to come to the village for collection of the loan amount. Subsequently, there was acquaintance and the intimacy was developed. And on the date of occurrence, the
Charge sheet filed.
Yes, ma'am.
That's it, fine.
376.3.
But 31 years old. Medical report is silent. And the victim stated that on the date of occurrence, the present petitioner at midnight went to meet her. And while they were in their house, the mother-in-law and other family members they woke up and they contacted the present petitioner. Thereafter, the FIR was lodged, alleging that before 5 to 6 months back, the present petitioner once called her to Bhadra and inhaled something to her. Subsequently, she became senseless and the present petitioner put her in a room and committed rape. That is 5 to 6 months back of the death. And the investigating agency took steps to examine the person of the manager of the hotel who has been examined by the investigating officer under section 161 of the CRPC. She stated that on the date of occurrence, I may allow to read.
Tell me.
He stated that on the date of occurrence, both of them came and asked for a room, and I gave them a room. And after while leaving the room, they paid 1,000 rupees and they went away. The father of the victim has been examined. He stated that I got information. My daughter has developed intimacy with the present petitioner.
Okay. Yes, sir.
Madam, 164 statement, madam. Abiding statement. सुशांत कुमार बारिक मते फोन नंबर मागिला मु तांको फोन नंबर देली मोर गोटे फोटो को एडिट करी मते व्हाट्सएप रे पठेले जोथरे कि मो
circulation. However, after investigation, there is no offense under IT Act has been made against the petition. The victim is a married woman of 31 old, and the petitioner is also 31 years old. It has come on record that one of the witness, who is the owner of the hotel? one of the witnesses, Sankar Jena, who is the manager of Mahavir's resort. In his statement under 161 CRPC has stated that both the victim and the petitioner had checked into the resort and stayed in the resort, and subsequently next day stayed in the hotel overnight, and next day they checked out. Next day and they checked out. The statement of independent witness indicate that the petitioner and the victim had the victim had consensually accompanied the petitioner. Moreover, the medical evidence indicates that there is no sign and symptom of recent sexual intercourse. The petitioner is in custody since 11/3/2024. Regarding head to the nature of evidence so far collected and filed form part of the charge sheet, and the period of custody, petitioner is entitled. Yes. Next. Yes. Yes. Yes, sir. Page 20. Yes.
दरखास्तकारी श्रीमती आशा विजय नायक 22 स्वामी गौरव नायक सुशील स्थान नवीकृषि थाना पाटना जिला देवघर एठी मु 10 समय पढुते 6 वर्ष पूर्व उक्त श्री गौरव नायक को सह मो संपर्क विवाह होइतेला आमे स्वामी स्त्री भागे रहथि हम ओरसरु 5 वर्ष पुत्र संतान मध्ये अछि एटा होछि पुलिस रजिस्टर्ड द केस under 498A, 307 and 495. Thereafter, charge sheet was submitted. My lord, as per the charge sheet was submitted under 363, 376, 376 2A and others.
Yes, sir.
164 madam.
Admittedly, she is married.
My lord.
Minor but married.
At the time of occurrence, that victim left.
What happened to the marriage now?
Another child has also on that.
Subsequently, 2 child.
If the petitioner is in the custody since.
What do you want?
Yes, I am ready. I am not concealing anything.
Custody since.
Custody since 23/8/20.
Yes.
Who
are you? You are a girl or father? Informant. Who is the informant? Girl herself is the informant. Okay.
Sir, thereafter he has kept another lady after getting married with a.
No, that may be the reason for the.
And at the time of occurrence, the victim was taken over by the accused petitioner, and thereafter kept relationship. Thereafter he got married.
How the child, when she was studying in 10th standard, she was got married with this victim, this petitioner.
2 minor son is there, minor child is there.
Then?
Their family members are threatening to terrorize the victim.
That's a different story, but keeping him inside jail will not solve any purpose. Ultimately, what do you, these people now, you are 22 years. Have you filed any proceeding for maintenance or anything? What to do? He is entitled for bail. He's entitled for bail, otherwise the other things I can understand, but what to do in the bail? What condition you tell me? Oh, those conditions will be there. Anything to protect your rights or anything. I can't ask give maintenance. I can't do all these things. You should initiate some proceeding. It's a very harsh case, right? Of petitioner is accused in some case. Which is on for appealing for informant. Yeah. The informant who is victim in the case has complained that she had married with the petitioner and happily residing with him. Out of the wedlock, he was blessed with a son. Blessed with a son. Subsequently, the petitioner developed relationship with another girl. Therefore, there is a matrimonial discord. Hence, he has filed the present petition, present complaint. After investigation, charge sheet has been filed. Petitioner is in custody since 23/8/2023. From the evidence is revealing. From the evidence is revealed that the petitioner will be legally petitioner is the husband of the victim, and they were blessed with two children. The petitioner has developed relationship with another allegedly developed relationship with another lady. That's the reason the FIR was arrested against him by the present victim. The victim informant at present is 22-year-old, but at the time of alleged incident, he was a minor. Therefore, POXO offense under POXO Act has been invoked. The petitioner is in custody since 23/8/2023. Regarding to the fact that the petitioner indeed is married to the victim and they were blessed with two children. I'm inclined to admit the petitioner on bail. Yes. But with conditions, all the conditions, additional conditions.
62.
26/4. Yes.
I filed an interim application. Ground of illness of my mother, madam. Mother is suffering with cancer, madam. And though I have two brothers, but they are very separate. And my father is an old elderly person, madam. No person is available to take care of his mother, madam.
306.
306, madam. 400.
Initially,
my lord, 302, and that charge sheet submitted.
302.
Initially registered, my lords. FIR registered.
Now 306.
Now 306. 498.
How she died?
My lord, the cause of death is, my lord, as a result of antemortem hanging, my lord.
Hanging, but you tell me.
Suicidal in nature, my lord.
No. Inside the house.
No, only one statement. Update sheet is not there, madam. Only one statement.
Get this.
I have also told my wife to bring some money from his parental house.
Statement of the complaint. Sasikant Bari.
No, suicide.
My lord, I am reading the statement of the complaint, my lord. ମୋର ସାନ ଭଉଣୀ ସଞ୍ଜୁତା ବାରେ ବୟସ 35 ସାହୁପଡା ଗ୍ରାମର ହରେକୃଷ୍ଣ ପତି
Read the relevant part.
ବିବାହ ପରେ ମୋର ଭଉଣୀ ସଞ୍ଜୁଲତାର ସ୍ୱାମୀ ବାରମ୍ବାର ବାପ ଘରୁ ଟଙ୍କା ଆଣିବା ପାଇଁ କହୁଥିଲେ ମୋର ଭଉଣୀ ଏହାର ବିରୋଧ କରିବାର ମାରଧର କରୁଥିଲେ ମୁଁ ବହୁତ ଥର ଆସି ମୋର ଭିଣେଇ ହରେକୃଷ୍ଣଙ୍କୁ ଏ ବିଷୟରେ ବୁଝାସୁଝା କରି ଯାଇଛି କିନ୍ତୁ ସେ ମୋ ଭଉଣୀକୁ ମଦ ଖାଇ କରି ଆସି ସେ ବହୁତ ମାରଧର କରୁଥିଲେ ମୁଁ ମୋର ଭିଣେଇକୁ ବହୁତ ଥର ଟଙ୍କା ଦେଇଛି କିନ୍ତୁ ତାଙ୍କ ଲୋଭ ଯେ କି ମୋର ଭଉଣୀ ଆମଠାରୁ ଟଙ୍କା ନେଇ ତାଙ୍କ ଆଉ ସେଇ ଟଙ୍କାରେ ମଦ ପିଇବ ମୋତେ ମୋର ଭିଣେଇ ହରେକୃଷ୍ଣ ପତି 24/4/24 ସମୟ ରାତି 12:30 ଫୋନ କରି କହିଲେ ଯେ ତୁମ ଭଉଣୀ ଦୌଡ଼ି ଦେଇଛି ତାପରେ ମୁଁ ସୁକାନ୍ତ ଚନ୍ଦ୍ର ବେହେରା ବଡ଼ ଭାଇ ରମାକାନ୍ତ ବାରି ଛୁଆ ଭାଇ ଉମାକାନ୍ତ ବାରି ଅନ୍ୟମାନେ ସେଠାକୁ ଆସି ଦେଖିଲୁ ଯେ ମୋର ସାନ ଭଉଣୀ ତାଙ୍କ ମାଟି ଘରେ ଶୋଇ ଦେଇଛନ୍ତି ଧୂପ ଦେଇ କିଛି ଲୋକ ବସିଛନ୍ତି
Door was bolted inside or anything of that sort?
No, my that statement is not there. Update CD is required, madam, in this case.
CD, call for CD, I'll consider regular bill. Regular bill, call for CD. Next.
63.
Yes. Name it first.
Pilot may see the order passed in 1970.
Hmm.
The can see the order dated 1970.
Yes.
Please. The pilot is a baptizing lawyer of this part. It alleged that he has taken money to be deposited in a GRP case. But instead of depositing, saying that has been.
A proceeding was going on DRT. The client gave you the money to deposit. This happened.
This Honorable Court, considering everything matters, directed the petitioner to pay some money. In between, my lord, 45 lakhs has already been paid.
45 lakhs.
My lord.
Total was 1 crore 49.
The claim of, my lord, the informer is 1,49,006. But the petitioner says he has received 79 lakhs.
70 lakhs.
79. 79 lakhs in his bank account. He is disputing the other.
Mediation didn't work.
Mediation is going on. And on 5th it is posted. In the meantime, the petitioner has paid also 3 lakhs more after the 97.
So, see, mediation is successful or going on? What? Going on. Let it go on. Go on. It is extended till next date of hearing. The interim order granted. I'll just see. The matter was referred to mediation. Matter was referred to mediation by the coordinate bench. The mediation process is still going on. In the meantime, interim protection was interim bail was granted to the petitioner, which expires today. Expired yesterday. The senior counsels appearing for both the parties conjointly submits that the mediation process is still going on, and matter is fixed before the mediation cell on 5th. In view of the aforesaid, the interim bail granted to the petitioner shall be extended for another period of 1 month. 1 month. Meanwhile, 1 month and
one stipulation. We have got the last part of the order, last order, that in the meantime, it is based on.
Yes.
1 month. 1 month. Okay.
That should be record. So that
he is a lawyer. जुगाड़ करके दबाओ कौन खाई रही पैसा. And any disciplinary proceeding? No.
Yes.
Any case. It is serious misconduct. Serious misconduct.
Immediate pilot.
So we are more interested in disciplinary action. We are interested in.
Whatever money you can get is the best thing. Naturally. No, better if the criminal case is dropped, he may get benefit there in disciplinary proceeding. May get benefit, I don't know. So better that you pay the money and settle with this thing.
I have also instructed him to ask him.
To save his license as well as the further incarceration.
This is the unfortunate.
Okay. 65. 1 month extended, 65. Yes.
My lord, I pray for adjournment, my lord, because RN Singh will argument. Next
Cancellation
week,
of
my
bail,
lord.
my lord.
66.
It will take up next week, my lord.
No, we'll see. Yes.
And-
66.
Yeah, please, madam. In the meantime, a informant already reside with his husband's house, so that our date may be fixed. The proceedings will be dropped, my lord. The FIR lodged before this police station and the GR case is
The
pending.
dispute is arising out of a matrimonial dispute. The land council for the petition submits that the parties have settled the dispute and the informant has started residing with the accused petitioner. He seeks an adjournment to place on record the said facts, lease the matter. Yes.
67.
On behalf of Mr. Acharya, I will please request. Here the petitioner before Lordship is the informant. Is agreed by the order passed by the London magistrate accepting the final report, rejecting my protest petition. My protest petition was accepted initially. The London magistrate recorded the statement under section 200 CRPC, also conducted inquiry under section 202 CRPC. Thereafter, while dismissing the order under Annexure 7, your Lordship will find there is no reference to the inquiry conducted under section 202 CRPC.
Yes.
Only
it's not
the,
necessary, but if there is no material, there is no material. What to do?
but that should have been dealt with because the 202.
Show me from evidence.
Well, that 202 statements are not available with me,
Then?
but 200 complaint petition complainant initial statement is there at page 21.
Complaint, you get the complaint. Mr. Mahapatra Land Council for the.
May I pray your lordship may call for the GR case record so that.
No, you are asking for question. Don't pardon the court like this. You come with your petition. File.
No, I am the complainant.
Additional document is substantive case, lease the matter. Yes. Next.
68.
Yeah, please. Time. As per your lordship.
Time.
For your lordship direction. I have to surrender before
August.
20.
For the reason stated in the application, the application is allowed. The time for surrendering and appearing before the court below. Time for surrender for the petitioner to surrender before the court below is extended appeal on 25th of 25th and avail remedy as per law. It is made clear that no further extensions are being granted. Yes.
69.
69. What is this matter?
Miller. Watching the entire proceeding, Miller. Charge sheet file 498 506 34 IPC.
Nobody is there.
None of them urgent.
Defects cured? Cured or not?
No, defect 3 is there.
Earlier, how many defects? Despite the specific order dated 30th 4 2024 to cure the defects. Defects have not yet been cured, and thereafter the matter was listed on 9/5/2024. 24 on that day 24. Next no steps have been taken. None appears for the petitioner. Which item?
Pardon law 69 item.
Same item. Yes.
Your lordship for removal of defects, your lordship.
No, I'm dismissing it. This is no way. You see the pressure and you take. I gave the time in the month of April. You didn't do. Thereafter the matter was listed on again May. You didn't do. Now very jolly well you are coming and asking for time. Dismiss.
Large sums may be given.
Dismiss for non-presence. Next. Some stringent orders has to be passed, otherwise you take things very granted, yes. 70, dismiss. 70 years.
Paper 2 weeks time to issue fresh
Police
notice.
party to served or not?
No, not sir. Answer.
Why?
Step for service notice not yet taken. Still answer now.
And not, you have not taken the steps.
2 weeks time.
No,
Last time.
No, see, just this matter is pending since 2023. 28/7/2023, notice was issued. Thereafter, again matter listed on 19/2/2024. Then again listed on 6/3/2024. Again now listed 9/5/2024. And today you are again asking for time.
And last time.
No, last time. And then I'll impose a cost of 5,000. Will you take it or not? I have to be very strict, otherwise we can't manage. You can't take the case, so like.
Within 2 weeks.
No, maybe. Right. Despite repeated opportunity granted to the petitioner to take steps for serving opposite party number 2, no step has been taken. And today, again, the petitioner is seeking 2 weeks time. I'm not inclined to grant any more opportunity. Hence, the petition is dismissed. Yes, next.
71.
Your Lordship,
It is unnecessary piling one after another matter. There is a limit to everything.
Your Lordship, item 71.
Yes, madam.
Your Lordship, some time to remove the defects.
Same story here.
Yes, Your Lordship.
Same story here.
Yes, sir.
Dismiss. Write down. On 1/5/2024, Learned Counsel for the petitioner sought 1 week time to cure the defects. And subsequently, the matter was again listed on 5/8/2024. The petitioner again sought 2 weeks time, 2 days, 2 working days to cure the defects. Today, when the matter is taken up, the Learned Counsel for the petitioner seeks further time to cure the defects. I'm not inclined to grant any more time for curing the defects. Therefore, the petition is dismissed. Yes, next.
72.
Yes.
On the basis of co-accused statement,
yes,
one Susanto, I have been implicated in this case, Your Lordship. And in the meanwhile, Your Lordship, 3 other co-accused persons released on bail.
Your bail application is rejected.
Yes, correct. I made first half, second half paid this.
Counsel for the petitioner seeks to withdraw the petition. Now, petitioner is seeking quashing up for the entire criminal prosecution initiated against him. Initiated against him. His bail plea has been rejected by this court. Anticipatory bail plea.
No, that is Your Lordship custodial. One is custodial by this court, 2 other by the court.
Sorry, how many of you?
3 co-accused persons released on bail.
Hey, what about you? You are absconding or you?
But the case is under investigation, Lordship. Charge sheet has been filed. And my answer bail application turned down.
Rejected. No, that's what I'm saying. Yes. Anticipatory bail plea has been rejected. Learned Counsel for the petitioner, Mr. Janna, submits that in the meantime, during the investigation, in the meantime, 2 of the three of the co-accused persons have already been enlarged on anticipatory bail. The investigation.
No, custody bail
are in custody and regular bail.
Custody bail, regular bail they will get.
Regular bail. Also, they got regular bail. The investigation is still going on. Investigation is still going on. He seeks to withdraw this petition to appear before the investigating officer. Anyway, what?
Both the courts to be disposed of my bail application, Lordship. First or second one.
He seeks to withdraw this petition to avail remedy under law for grant of regular bail. Regular bail. He may surrender oblique appear before the concerned court on or before 25th of this month and move appropriate application for regular bail. If such application is moved, the same shall be considered on the same day. Yes.
By both the courts, Lordship. Both the courts.
Yes.
Oblige, Lordship.
73.
Adjourn. 74.
74.
May I please? Lordship, pay for 1 week time for the removal of the defect, Lordship.
For the petitioner seeks 1 week time to cure the defects pointed out by the registry. 1 week time is granted. It's made clear that if defects are not cured within 1 week, the petition shall be dismissed without reference to the court. If the defects are cured, release the matter. Yes.
75.
May I please, Your Lordship?
Yes, sir.
This is for quashing of the cognizance taken by order dated 27/2020, my lord.
Yes.
In the PS case number 10 of dated.
Where is the charge sheet?
When I called for the charge sheet, they sent a 2 letter in my WhatsApp, my lord. Can I get it? Yesterday I received it.
You are challenging the cognizance order, you have to file the
No,
charge.
I have called the order, I have challenged that, my lord.
Huh?
That order I have challenged.
I know, where is the charge sheet I am asking you? Charge sheet has to be filled.
Charge sheet then.
Let on counsel for the petitioner seeks 1 week time to place on record the copy of charge sheet. Lease the matter after 1 week. Yes.
76.
Yes.
Lord, on behalf of Mr. Roth, seeking an adjournment.
Yes, sir.
Seeking an adjournment on behalf of Mr. Roth.
Sorry?
Seeking an adjournment on behalf of Mr. Gauri Mohan Roth.
On behalf of?
Mr. Gauri Mohan Roth. The opposite party.
Every day after tomorrow.
Let counsel for the petitioner seeks an adjournment.
My lord,
Lease the matter.
immediate not but not 6.
We will adjust our board and give it. Can't give it like that. Yes. Next.
77.
Oh, October last week. Yes. Yes, sir. Yes.
Written notice in spite of direction to the IO, also special message that the OPO is not appealing. The husband and disputes already judicially separated. Permanent alignment.
Yes.
Madam. The special message was also sent. Marriage somewhere else and.
IO was directed to serve.
Under the obedience to the order of on report, my lord, on 21/8/2024, I have honored to submit that notice as well as the application has been served to the informant, namely the Priyadarshini Behra, Pragyan Priyadarshini Behra, wife of such and such, on 26/8/2024. Acknowledgement copy of this said notice, my lord, notice already served, my lord.
Sure.
My lord. On 26, my lord, 8/2024.
What happened? They separated and
Separated, they have already taken the permanent alimony. Only.
But since 26/8, my lord, last month, my lord, they received it. Somebody may have to know what.
Pursuant to the
First time
order dated state of 20/8/2024, the IIC, the IO of the present case, that is Mahila Police Station, Bhubaneswar, has served the opposite party number 1 and submitted a report
by the IIC Mahila PS.
Reported through IIC Mahila Police PS, entirely stating that the opposite party number 1 has been served on
26/8/2024.
26/8/2024. Since the opposite party number 1 has been recently served, it would be appropriate to afford one more opportunity to the petitioner, lease the matter. Hence, in the interest of justice, urgent to Monday, Tuesday. Was it? Tuesday or Monday? Yes.
78.
It's a domestic violence, husband wife local gentleman intercept person. Perhaps it is parent, so 2 weeks.
2 weeks. After 2 weeks. Yes.
79.
Entry motor.
Entry motor.
And number 2 in the state informant.
You are for information.
Lordship, Lordship, I'm appearing as a petitioner. Lordship, on behalf of my landlord senior Mr. Milan Kanungo, Lordship he's on his legs in another court. I pray for a short adjournment.
You have an interim order, you are, this is going on 22.
May I make a small prayer? Lord?
Yes.
Probably this has become infructuous because they have challenged the prayer for passing of FI. In the meantime, investigation completed, cognizance has already been taken. That I have, your Lordship may kindly, that I have already filed. My Lord, so it has no.
On your counter affidavit page 2.
Huh?
On your counter affidavit page 2, so submit this before let's say.
That is already there. That is already have submitted. Only for page reference and already have submitted. Already charge sheeted and cognizance has been taken.
You challenge the cognizance order, whatever.
420, 406, 465. So it is not the appropriate time
This
to.
matter is pending since 2022. Pending since 22/11 to 2022. The coordinate bench of this court, while issuing notice to opposite parties number 2 on 22/12/2022, have passed an interim order. And the interim order is since then continuing. Interim order since then continuing. Meanwhile, after investigation, charge sheet has been filed in the present case, and while order dated 28/11/2022, JMFC Roman 4 Bhubaneswar has already taken cognizance of offences under section 420 and 406 IPC against the petitioner. In view of the aforesaid development, not inclined to entertain this petition, hence the same is dismissed. However, liberty is granted to the petitioner to avail the remedy under law in the changing circumstances.
My Lord, may I make a small prayer, Lordship? Since it has been stayed for long and I am an old lady, your Lordship, 80 lakhs in my property has been cheated. May I pray that your Lordship may direct for expeditious trial by.
No, in his petition you want relief. What is this? My Lord. You are the respondent, you don't forget. You have not come. He has come. I am dismissing his petition, I will give you relief. Very nice.
That your Lordship can direct.
Okay, you can ask anything, whatever you want. It is his petition. I am dismissing his petition.
Your Lordship will decide.
You want relief in his petition.
Because it has been stayed for since
You
long.
may, what you are making? This very funny. Yes.
I file a separate.
You
petition.
do whatever you want to do. Yes.
80.
Yes.
But in 80, I am for the opposite number 2.
Yes.
I'm praying for an adjournment, my lord, on behalf of Mr. Mahapatra. On behalf
My
of
lord, in
Mr.
item eight-
Mahapatra, I'm praying for an adjournment, my lord.
There is a prayer for adjournment.
My lord, I have no objection, but they are husband and wife. Your lordship may direct to appear before the local mediation center.
My lord,
This is for causing.
my lord.
This is for
Oh, man, they-
227
against
petition
the
was
order of-
rejected. 227 petition was rejected.
Against that, they have come.
First minor, they have filed one 227 petition.
498 and all.
498 was deleted. Then minor, he has filed a second application under section 227.
220
That was
in
rejected. Against that order, he has filed the CRLs.
227 was partly allowed.
Next. Okay.
And 307, 354B.
Babe. On
Yes,
last
sir.
occasion, your Lordship directed to the State Council to take the instruction. Your Lordship may can see the last order sheet of your Lordship. Oh, yes.
Yes, my lord, instruction that my lord senior saying that he has 5 number of cases was in filed by the present victim, my lord.
I have annexed
But
two cases.
I have no instruction. That number may be given, I will take instruction of that.
Next one.
Pertains to the order dated 12
সেটা করতে, পাঁচটা
2024, the State Council have not obtained instruction and seeks one more opportunity for compliance of order dated 12/8/2024. Release the matter. Yes. Entry order.
My lord, after 2 weeks, my lord. And he may be provided the case number, my lord.
Service is also weighted. That will be found. Service on opposite party number 2 is also weighted.
That has been, litigated already been filed here now.
Next.
And my lord, he may be provided the case number, that detailed case number.
Entry order may kind of continue.
Entry mode to continue.
My lord, say,
Yes,
in this,
Mr.
my lord, may I please your lords? Here, my lords, order dated 5/10/2023 is under challenge, my lords. Here the fact remains, my lord, that is case counter case, and my affair was presented before the PS first, and that is PS case number, my lord, 352. That was registered against me. My lord, if your lordship will kindly turn to annexure 10.
You are seeking quashing of which FIR?
No, I am not seeking passing. I am only seeking deletion of 307. 307, I filed a petition with annexure 3, and my specific stand was, my lord, injuries were simple and nothing has been attributed to me. But still then, my lord, 307 charge sheet was filed and the court has fixed the matter to tomorrow for consideration of charge. And
you moved an application with your turn down.
Yes, annexure 3 is the application, annexure 4 is the order. And the last occasion also CD was called for, notices were issued, and this is the injury report. And this is that there is no motive, it's arising out of a civil dispute. And also this and there is no weapon of offense seized, my lord. There is no repeated or severe assault, my lords.
By means of deadly weapon?
It's all the allegation is on bricks, my lord, and the allegation in the FIR is I have assaulted with a cutlery, my lords. Both are neighbors, my lords. Annexure 1.
That's right, but the 307, see, if you have an intention, that's
Lord,
enough.
it has not, your lordship kindly see, my lord, annexure 1, only for page 10. This is the FIR lodged against me. My lord, if your lordship will turn to page 12, and operative portion is page 13. It was presented against me, my lord. That was on 12/7 last part, my lords, page 13. Presented on 12/7/2021, my lords. So far as the second FIR is concerned, my lords, page 15, lordship. That is my FIR, FIR, my lord. And if your lordship will kindly turn to page 18. This name is my wife, this Asmita has filed, and after the name, my lord, is presented on 9/7/2021 on the middle, my lord, before, after the signature, below the signature. And it was received on 12/7/10:37 PM, my lords. And the FIR against me in 10:36, my lords. So
what do you want to bring out?
My lord, bring out, my lords, what I humbly bring to your kind notice that though there is a chronic civil dispute and FIRs were registered, and though my FIR was first, but that was registered later. Since there was 307 was not attracted, my lords, the petition was filed.
307 is attracted because it says that deadly weapon you have used.
My lords,
you caused bodily injury. Whether you had intention or not, that will be tested in the trial.
So far bodily injuries are concerned, if your lordship will kindly see the injury part, my lords, that cause, my lords, nature, my lords, the reason being that bricks and so far as my part is concerned, my lord,
bricks, if your intention is to, yes, tell me.
So far, my lords, this injuries part is concerned, my lords. And so far the case is that, my lords, I was holding a weapon, my lords.
That's right.
But so far injury attributed and the cause is, my lords, is all bricks and stone, my lords. So, my lords, the weapon of offense and the injury caused are no way related, my lords.
No, first one is the laceration 2 into 1.5 half right side
Yes.
in the hard blunt of weapons. Second one is the laceration 2 into half and half back side of the head, simple in nature, caused by the hard and blunt.
Mr. Mahanti, you don't have a case. You argue all this point at the appropriate stage. You don't have a case. 307, whether it is made out or not, that can be tested there only. There are injuries, weapon is used, and whether you had a knowledge that the same will cause death or not, those things will be tested there in trial.
Your lordship, that way, my lord.
What do you want?
Lordship,
Withdraw to argue all this point. Mr. Mahanti, Land Constable
Liberty.
petitioner seeks to withdraw this petition to argue all these points before the court below at the appropriate place. With this liberty, the petition is disposed of. Yes. Next.
Yes.
Before-
Let me-
Yes, sir. Yes. Service complete. Yes. Who is appearing for opposition?
Your Lordship, I am appearing for the opposite party too.
Yes.
On behalf of Mr. S.K. Vishwal, seeking 2 weeks of adjournment.
Adjournment is as if you have a birth right. Right now. So entered appearance on behalf of opposite party number 2 and seeks an adjournment to oppose the petition. Leave the matter after 2 weeks. Yes. He has been recently served. He has the right to do it. Yes.
86.
85
Yes.
There is a delay of 20 years, no trial has been conducted against me. So on the account of delay for quashing of the entire prosecution case against me.
How many years you were absconding?
I am never in the absconding, I am on bail, Your Lordship. And Your Lordship, because the previous order, Your Lordship asked my Lord statement to obtain instruction vis-a-vis instruction from the Lord court below. What report has been came, that may not be suspended.
A report has come?
No.
Yes,
That
the
instruction
report-
is to be obtained by.
No, listen to me. But it shows that Your Lordship report has been come, that is on the record, Your Lordship. And the flag X, Your Lordship. Yes. And judgment of our own High Court of Lordship, 10 year, 12 year delay.
Case record is misplaced somewhere.
This is not a latches.
It says that the case record is not traced out. For the reason the status of the case is not known. Endeavor by the staff is going on. Trace out the case record to find the status of the case, and so more time is necessary. They are not able to trace the record.
Their latches, Your Lordship, for this, their latches can I suffer, Your Lordship?
But the SDJM Bhubaneswar is seeking one more opportunity to locate the record and file the status report.
One more.
Right out. By the letter dated 31/8/2024, the SDJM Bhubaneswar has communicated to this court that the status of the present case could not be furnished because the case record is not traceable, and they are taking all the and they are making endeavors to locate the record and file a status report for which some time is sought. Accordingly, 2 weeks time is granted to
Specific date may calculate.
the 2 weeks time is granted for furnishing the report on behalf of the STJM. Okay? Communicate this order to the related court of STJM. Please the matter. Yes.
Specific date may calculate.
Yes.
87. And this is not, you know, when they have your Lordship border is live with them, they are writing this type of letter, not this code, other code is also.
I will wait for that and call. Yes.
48 ବର୍ଷ ଆଜ୍ଞା I am in service due to pendency of this case. I am unable to take my benefit of service.
I know. We'll quash it after getting the report. Yes. Only to ascertain whether you are the delay is
No, I was
attributed to
arrested 2004. I arrested. I released on bail.
Let us see. Let the report come.
And thereafter the case I got no charge sheet has been filed 2008. Thereafter Lordship no summon nothing, and the case is now 20 years lingering. And prosecution my friend is ASU record again the ASMAS
Yes. Next. 87.
Maybe reconstructed, but I may be even passing.
One set must be with the police.
87.
My lord, 87, I have prayed for watching of the entire proceeding. Being satisfied, your lordship was pleased to grant this stay. And if so, one is a FIR against us. that is lost at 9:45 p.m. Annexure 2 is the FIR lost by me, which is at
You are opposing.
9:05 p.m.
Yes.
So it is counter to my FIR. This annexure 1 has been lost.
Yes.
Lordship may kindly draw to page 13.
Madam, are you ready?
Yes, Lordship.
Ready?
Your Lordship.
Yes, Mr. Raghuda, ready?
Madam, what happened is both the cases charge sheet submitted. Charge sheet has already been submitted. Both the cases. Case and counter case.
Okay.
But if it's sent to the mediation ballot, then that might be valid chances. Yes, counter case.
Mediation,
Doesn't
I
happen,
have
sir.
no objection.
Stay is cooperating. You try.
Both the cases charge sheet submitted.
Stay, there is a stay. I have already passed a stay order.
Yes.
So you can very well try once. What is wrong?
No problem.
Stay to continue.
Yes.
There is there is Mr. Sudata Jena, the counsel for the petitioner submits that persons to the FIR C laws as a counter a counter blast to the FIR, a subsequent FIR has been filed against his her clients. After investigation, charge sheet has already been filed in both the cases. I have already passed an interim order interim order. What kind of interim order is that? Interim order staying the further proceeding. Further proceeding in GR case number 978 of 2023 arising out of Krishan Nagar PS case number 195 of 2023. Mr. Raghuda, counsel of the state submits that since the charge sheet has been filed in both the cases and there are cross cases, there are all possibility of settlement between the parties. Regarding head to the aforementioned, I feel it appropriate to send the parties to for exploring the possibility of settlement. The parties are relegated to High Court Mediation Center or some High Court Mediation Center. Coordinate of the mediation center is directed to which date and communicate the same to all concerned for the purpose of exploring the possibilities of settlement. Awaiting the settlement report, this matter on to interim order to continue. Till then, Mrs. Jana also undertakes to serve the copy of this order. Both of these, since the counsel for both the parties are present, they shall inform the present order to their respective respective clients, so that they can participate in the mediation process. Yes. Date will fix after 3 weeks. After 3 weeks. Thank you.
88.
Yes, so application for default bail, Your Lordship. Previously, Your Lordship issued notice in this matter, my lord. Lordship may kindly turn to the list of dates.
Notice was issued.
Your Lordship.
What happened?
Your Lordship may kindly turn to list of dates.
Service.
State is only the
Only
part.
state, okay.
Oh, because you default bill. Your Lordship, on 9th June 2022, the FIR registered. And on 3rd August 2022, the IO submitted a petition before the learned court below for remand of the present petitioner, my lord. Thereafter, Your Lordship, on 8th August, the IO submitted preliminary charge sheet without mentioning my name.
My lord, as per noting, extra copy not served, my lord.
Already served. Previous date I served. My lord, previous date Mr. Raghuda appeared, I served extra copy in the court.
Not and
court रे दिली है.
What do you want? You want
Default bail, Your Lordship, because
Huh?
my lord,
default?
2 years completed, my lord, no charge sheet submitted against me.
You are still in custody.
Yes, Your Lordship.
You have not tried regular bail.
Regular bail 5 times rejected. Because my lord, below commercial quantity, my lord.
How much?
And that is a 39 gram 500 milligram. Because he have one antecedent, the police stated, he have one antecedent, that case is 8 gram 150 milligram. For that reason.
In that case.
My lord. What happened in this case, my lord? Police.
You are in custody since?
Since 31st July 2022, my lord.
Yes. Yes,
In
Mr.
the cases, my lord, the police not submitted charge sheet.
So the my lord, the instruction sought for my lord, but in fact, my lord, that has been not come, my lord. But in fact, my
No,
lord,
you tell me your default bail under 167(2) you are seeking.
Yeah.
Thereafter, regular bail is rejected.
Initially, the regular bail.
No. After your application on
there are
167(2),
4 bail
then
applications.
you are 439 is rejected or not?
No, my lord. No.
There are, my lord,
No, Your Lordship,
I have-
kindly turn to the
there are
certificate.
4 bail applications, my lord.
That
will BL number.
Earlier. BLPL number 922.
It's all right. That's what
My lord.
a legal issue that.
Yes, Your Lordship. This is the last order where I'm telling you.
Yes.
But, on 31st 5/2024, my lord, instruction was sought for, my lord, but that has not come, my lord. Another opportunity given for that.
In the meantime, Your Lordship may kindly.
The state police secretary he has not received the instruction. Release the matter of one week. Yes. Awaiting instruction.
Your Lordship, they have not submitted charge sheet 2 years already.
No interim order could be passed.
I'm praying, Your Lordship, interim bail may kindly can be.
How can it? Regular bail rejected, interim bail in 167(2).
My lord, in Muhammad Arbaz,
If you are, you can satisfy me that it's a case of 167(2), I will grant the.
Your Lordship, aware about the Muhammad Arbaz case, my lord. That SLP is pending before Honorable Supreme Court. In the meantime, the Honorable Supreme Court granting interim bail.
In the absence of EC report. In the absence of EC report.
Yes, C report.
Your lordship also give judgment.
But if by now report might have been filed.
My lord, not in this case they have not submitted charge sheet, Your Lordship. The C report is the secondary.
Oh, then what to do?
Can take on Friday, my lord.
Then entitled for interim bail.
Interim, my lord,
because in all the matters where this report is not there,
he has to approach the trial court, my lord. For interim bail, my
Your Lordship, I have
not
submitted.
in
Why
the
don't you go?
not
Your
in
Lordship,
court,
I have
my lord.
submitted entire.
I will record that. You go and
Exactly.
My lord, already 167 subsection 2 application disposed by the learned court below. If Your Lordship will direct, then he will also dismiss that. Same.
Then you will come in.
Again, my lord, I am not.
482, my lord, cannot be, my lord, utilized.
No, you let it be pending. You go and apply. Go and apply.
Your Lordship may kindly observe.
At this stage, Mr. Sahul and counsel for the petitioner submits that in view of the judgment of the Supreme Court in
Muhammad Arbaz and bench matters.
And so the petitioner is entitled to interim bail because in the present case the charge sheet has yet not been filed. Much less filing the chemical analysis report. He is in custody since
31st July 2022.
31st July 2022. Therefore, he is entitled to interim bail. As in similar cases, which is pending consideration before the Supreme Court. Interim bail has been granted to all the co-accused persons. I am not inclined to entertain this oral prayer before this court. However, liberty is granted to the petitioner to move appropriate application before the trial court for grant of interim bail. If such application is made, the same shall be considered on its own merit. Least the matter. This matter least after 4 weeks.
My lord, 4 weeks.
3 weeks. So 3 weeks you get interim bail. I have given that liberty. Go on.
In the meantime, the state may call for the CD and charge sheet.
Oh, that will do.
Final charge sheet.
Final charge sheet asking to
ଦେଖିଆ ସେ ଦେବନି instruction ଦେବନି।
And now you try your luck there if you get entry mail, nothing like that. Yes.
Final charge sheet.
Yes.
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 I'm from the opposite party.
May I please, my lords, I am appearing through virtual High Court, Sambalpur, my lords. I am the petitioner in this case, my lords.
Yes.
My lords, I have approached this honorable court seeking quashing of order, impugn order under Annexure 5 series, my lords.
Yes.
Wherein my prayer to send the disputed checks under Exhibit 1 and Exhibit 2 to FSL for opinion of handwriting expert and forensic science opinion for the aging of ink and writing on the checks were rejected, my lords. The case is under section 138 of the NI Act, my lords.
You are the accused.
I am the accused in this case, my lords.
When the complaint was filed, 2018.
2018, my lords.
Check amount?
Check amount is, there are two checks according to the prosecution, my lords. According to the complaint, there are two checks. One covering an amount of 4 lakh and another one covering an amount of 4 lakh 2.
Yes.
Both the checks of 4 lakh each, my lords.
Yes.
So my ground, my lords, is that if your lordship will peruse the record, the uncontroverted stand of the petitioner so far, the trial has concluded to a sufficient extent, my lords. My uncontroverted stand is that I have issued the checks. I have agreed that I have signed the checks. But my contention is that I have issued the checks undated and without filling the contents. Now, on the other hand, the contention of the opposite party, who is the complainant, is that I have issued the accused has issued the check under her signature, but writing.
Show me the reply which you have filed to the statutory notice. Have you taken that stand?
Yes, my lords.
In the
I have
reply?
taken that. Yes.
Reply. Show me. Yes.
Give me a second. Yes. My reply is under in page number 34. My kindly the page number 34, my lords.
34, huh?
My
Annexure?
lords.
Annexure?
Annexure 2 series, my lords.
Oh, yes. Yes. Where have you taken that stand?
Para 3 of the reply notice, my lords. I have contended that I have received 4,52,000 in cash. That is also a mistaken to a certain extent, because in the court I have submitted that I have received 4 lakh in check and 52,000 in cash. So the deposition before the court has to be taken due consideration, my lords. Now in the reply, I have specifically stated that when issued 2 blank checks, undated, the checks were blanked, undated, my lords.
What is the check amount?
Check amount is 4 lakh each, my lords. It's a huge amount, my lords.
No, it's all right, but you have given blank check, then the presumption operates against you.
Yes, my lords, no doubt on that, my lords.
These are the instruments. You can't sign it and why have you given blank check?
Agreed, my lords. I respectfully agree what your lordship says. There is a presumption, but the presumption is reputable in nature, and I have every right to make every effort to review the presumption. This is how I have to create documents. I have to prove my case, my lords. Now, my case, if your lordship will peruse the impugn order and then Annexure 5. the only ground taken by the learned court below to reject my petition is the observation of the Honorable Apex Court passed in Oriental Bank of Commerce versus Prabodh Kumar Tiwari. Respectfully, I respectfully agree what the Honorable Apex Court observed, but my case is different, my lords. In that case, my lords, the said prayer for sending the checks for handwriting expert was made before adducing any evidence disputing the existence of the legal enforceable debt and liability. First, and the second ground, my lords, the accused therein has made such prayer at the very initial stage. My case, the fact and circumstances of my case is different, totally, completely different from that of the case in Oriental Bank of Commerce, my lords. And I'm relying on 3 to 4 judgments, my lord. I'm relying.
Where are the judgments? Do you have anyone in the court who can give me?
One of the, I have here with me, my lords. I'm relying on the judgments of this honorable court, the Honorable High Court of Orissa,
Can you give me these copies?
I can, my lords, but I'm appearing virtually, so in
can, but I have to come to you then.
No, my lords, please don't mistake me. There is a document reader.
You should have some briefing counsel. How can you rely?
There is a document reader here in my lords. There is a document reader. We can make use of the document reader here itself.
This is no way. In a 138 matter, limited scope of you send the copy highlighting, and I am reserving the judgment. I'll pass the order.
My lords, one more thing, my lords. By that time, there is an interim application, my lords, because the trial is.
I'll dispose of. You send the judgment. Somehow you send the judgment highlighting. I'll deal with it and pass the order. Yes, next.
May I make my submission, Your Lordship? I am
forget.
Okay.
Yes. 2018 is pending this, that.
My lords, I can understand. My lords, let me make one small submission.
That has been put for the final outcome.
Yes. You send
let me make one more small submission, my lords.
Yes.
Another opportunity. I'll submit the documents. I'll submit the judgments and all. Give me another opportunity to demonstrate my case, my lords.
See, 2018, the 138 matter, 2018, it should have been concluded by 6 months.
True, agreed, my lords.
This is going on.
My lord, true, agreed, everything agreed, my lords. But this is not on my part. This is not because of my failure, my lords.
Anyway, you have to
give me another opportunity. I'll submit all the judgments. I'll highlight those points. Give me another opportunity to demonstrate, my lords. Maybe in a week, my lords.
After 2 weeks. Yes.
Date may kindly be given, my lords. Yes. Date may kindly be given, my lords.
Okay. By that time, you will be convicted then. Yes. After 3 weeks.
Why should I be convicted, my lords?
Yes.
My lord.
90?
90 I have other day I have ascertained that all the appellants are alive. And
Sorry, I didn't follow you.
Last order, I have to ascertain the
revision against
well-being, wherever. All of them are alive.
Fag and one is 100 years and not like so.
These are the revisions and this is weekly. Well-being, Land Council for the petitioner submits that all the petitioners are alive and the matter could be heard. Least the matter in the weekly, yes. What are the offenses, sir, here? Let us see.
326 and 149 only the offenses, 3 years conviction.
3 years conviction.
My lord. And most of them, 2 already dead, my lord, during trial. And
are you aiming at an acquittal?
My lord, leniency.
Or I'll grant probation and finish it up.
PO act may extended.
Oh, judgment reserve PO. Unnecessary. Why these matters will be pending? I'll grant probation of offenders benefit. 326.
326.
Grievous tort. Or simple.
No, my
No,
lord.
One is grievous left hand.
My lord.
Do you oppose?
My lord.
Huh?
My lord.
No, then put it for hearing. Please, there is no opposition. There is no. Put it for hearing. Okay.
Here the pardon make a mention.
Yeah.
But something on the. There's an urgent IAF filed in a matter that has been running around to get it.
That those kind of mentioning in the morning. Don't do that. Yes. Anything related to today's board, you tell me.
Malad,
Today's board only. Yes. Yes, sir.
Malad, item 130, Malad, in the main list.
130.
Yes, I just.
Who is opposing?
On that case, my lord, the Bangalore police, my lord, came here, Odisha, and
Malad, in Bangalore
I
police.
think you mentioned
I
it.
mentioned 134, my lord. My lord may give any.
Mine is 130, Malad.
That Bangalore thing I have
Yes,
heard.
yes,
And,
yes.
Yesterday,
Mr. Maharaja,
Maharaja was also there.
No, the only thing is that, Malad, if the proceeding is allowed to continue, Malad, here, I'll have to face the trial. That's the whole problem, Malad. Malad, I came as part of the investigating team. But at least as far as I am concerned, let there be stay of the proceeding, Malad.
I stay now. I'll hear it and finish it up. But
Malad, I think it has been.
let us
they
fix
have,
the date.
the charge sheet has been submitted.
It is in the weekly list, my lord.
Weekly list.
Yes, Malad,
No,
charge sheet has been submitted.
Bring it to supplementary list and give a date.
What did you
Huh?
Dates are both good now.
Your matter also, I'll bring it to supplementary.
I'm coming on 11th, my lord. So my lord may have it if possible. Subject.
Put it on 11th. We'll see. Huh? Put it on 11th at 3 o'clock.
134, yes.
134 also on 11th. On 11th. Okay. 11th.
It can be.
I'll put it at 3 o'clock.
Yes.
11th at 3 o'clock.
Yes.
Your matter also, sir.
Mine
sometime
on 5th, Malad.
5th at 3 o'clock.
Obliged, Malad.
May I please, my lord, weekly list.
Interim order 134.
Interim order.
Okay.
May I please, my lord, weekly list item number 135. May kindly take up next week, my lord. Specifically, my lord, may kindly fix up a date.
You have been watching the proceedings since morning. You see.
My lord, because I.
Let it be there whenever there is a.
From tomorrow, I am not here in this.
When you come back, you tell me so that I can take it.
My lord, next week, may kindly fix up a
Let it
date.
be there in the weekly list itself. You come and mention.
Weekly list is very much
What to do? You
hardship to reach my.
so you let it be there in the list itself and mention after you come.
My lord.
Yes.
Much obliged.
Tomorrow you mention it.
My issue will be
Tomorrow you mention it because see there should be some system. Today's board if you want.
That is why I am so.
What is big eye about it?
Let's stop preservation of.
Preservation of what?
Electronic evidence on the records of the learned court below. The LMC has been stayed by my law here. And I filed that IA because that electronic evidence.
When have you filed that IA?
It was filed in July, my lord. By since
And
then,
July, today we are in September.
laws have been
And
running from-
no urgency, overnight it become so
There
urgent.
was an urgency law, but it was listed before another court law, which is going to be listed. It directed to be listed. It has been directed by the DR to be listed tomorrow, but the listing told
No,
us.
the listing
One matter
is
I
getting
wouldn't have-
upset because of.
I wouldn't have pressed for hard, you know, there's some urgency.
I know that. Dekhi jabe to.
Maybe for that.
No, not tomorrow. Don't tell all this thing.
Or
Yes.
day after Milos, we kindly fix it. That is all I'm requesting.
And it is pending since July, nothing happened. And all of a sudden overnight, all urgency.
Roster was changed, it wasn't before my.
Roster change, therefore the urgency. No. Let it be, let it be. Yes. Dekhi de de.
Lord,
Yes, Mr. Marana.
my lord, serial number 132 that is there in your lordship's board. I have filed a that is notice had been issued, but there is a flag B at IA for amendment is pending. If your lordship may kindly allow it, so
What
that
kind
is
of amendment is
my
that?
lord, in the cause title, the husband name is written different. So that is the
amendment allowed. 132.
132.
IA amendment allowed. You file
Consolidated.
team of parties. Okay.
Well, and interim order to continue, my lord.
Interim order to continue. Yes.
Yes.
Any mention? Tomorrow morning. He'll adjust the date and try to. Yes. Any mention? Thank you.
Just,